Item 13 and 14.
The parties are to avail the arbitration clause provided in the arbitration agreement and the contract agreement.
Where this are also. My lord, this two matter will be listed on 13 of this month, my lord.
Huh?
This two petition will be listed on 13 of this.
Why?
As of the settlement will be over by 31st March, my lord. So this is the against.
Okay.
Must have been. I was praying for listing of this matter on 13th.
13th.
13th March.
13th is what day? Wednesday.
Order matter.
Why? It's a new matter.
It is listed for 4 months now. It is listed last on 19/23. It is a little urgent.
Okay.
The side terms has not filed the petition.
Okay.
May I please adopt? My lord, yesterday I have withdrawn a writ petition with the liberty to file
File it right.
afresh. It is being filed now. So
Okay.
it may kindly be listed tomorrow.
Yes.
Lordship, I pray for listing on 7th March here.
7 March.
Yeah.
What is the matter?
So I am the licensee of
Is it a new case?
yes, Lordship.
New case.
Please, a lordship. Lordship, I beg to mention a matter for listing of an IA lordship in WPC 4.
For what?
Lordship,
For what?
lordship for indignant of party of Jal Board in yes, lordship.
When?
Lordship, this Thursday, 7th of March.
Yeah, please, Lordship. Lordship, I am praying for listing of a writ petition for motion tomorrow, Lordship.
Tomorrow.
Now, there is some urgency as arbitral tribunal has held on the 20% issue, my lord. It is proceeding contrary to the condition of the agreement, my lord.
Who is what? Arbitral tribunal?
Yes, my lord. We are challenging an impugn order passed by the Honorable Learned Tribunal, my lord.
You're challenging an order passed by the tribunal.
My lord. It has decided on the preliminary issues, my lord. Contrary to the condition of the,
Arbitral tribunal, you have a challenge under section 34
my lord,
before the district judge,
my lord,
not before this court.
clause 63 and 64 of the general condition, my lord.
Huh?
Clause 63 and 64, the general condition of contract, my lord.
Yes.
It is applicable to the settlement where the claim amount is less than 20%. My lord had recently held in one judgment, my lord. So it is on that.
Less than 20%, less than
20%.
20%.
Right.
So it should be done by the, it should be decided by the single arbitrator.
Right.
Then?
My lord, there is some urgency because tomorrow is the date fixed in the tribunal, my lord. And
Is,
claimants are
you
pressing.
said arbitral tribunal has been formed. Day after tomorrow?
My lord, tomorrow is date fixed in the.
So what?
Claimants are stressing on the fee issue, my lord.
Huh?
Claimants are stressing on the fees issue, my lord.
Mr. Counsel, I don't understand at all what you're trying to say. If an arbitral tribunal has already been formed, where is the question of stay?
My lord,
And can you, and arbitral tribunal, you're challenging the formation of arbitral tribunal or what? What are you
my
challenging?
lord, I'm on the impugn order passed by the tribunal. which is-
Impugn order, you go to the district judge under section 34.
my
Can
lord,
you come here?
It is pending, my lord.
Where?
It is pending, my lord.
Pending where?
In tribunal, my lord. Say 34, my lord, after the final
Day
order.
after tomorrow. Day after tomorrow.
My-
Huh? Quite number of fixed.
my lord, if possible.
No hurry, Mr. Counsel. You have not been able to, you are not able to answer the question. Next.
Wait, please, my lord.
Yes.
Wait, please, my lord. I pray for listening upon matter, my lord, on Thursday, my lord.
What? What is what?
There is urgency in the matter, my lord. It is the IMFL tender, my lord.
New.
My lord, what has happened is that they violated the terms of the NIV and also violated Rule 289 of the
Okay,
excise
day after tomorrow.
My lord, Thursday. Highly object.
May it please your lordship. Lordship, I beg to mention for listing of a writ petition, lordship. Lordship kindly for.
New case.
New case.
Regarding what?
Regarding a tender was a bid was submitted by the petitioner.
What was permitted?
Bid,
Bid.
bid was permitted by he was the
Respondent.
lowest bidder.
Ah.
Lowest bidder, but on 29/2, the tender was cancelled, and they have, on the same day, they have
Issued a fresh tender.
fresh tender without giving any reason, Lordship.
So you did not participate.
Lordship, on the, that earlier was cancelled without giving any reason, Lordship.
So you have not participated in the subsequent one.
No, Lordship.
We've got a lot of cases now planned. I don't know.
Lordship,
Huh?
only for tomorrow, Lordship.
When is the last date in that case?
On 13, Lordship, 13/2,
13,
13/2.
Monday, 11. Monday, 11.
Relax, Lordship.
May I pay for listing or matter for orders? This matter pertains to contextual bill of a contractor.
Contractual?
Bill.
Bill, no hurry. That will come in time.
Maybe
Yes.
the Lordship.
So need to take in an orders, sir.
Give a date, some date.
Date, any date. I did one. Thank you.
Lordship, I beg to mention for listing of a matter on Thursday, Lordship. It was last listed on November of 2023, but the matter didn't.
No
list.
time, no time. Give a date. Not
Then
time.
on 12 or 13,
14, madam. What is that? What is the hurry?
May I please proceed?
What's
Lordship,
up,
I beg to mention for listing for tomorrow. Lordship, the urgency is that I'm a contractor. My work was going on. My work has been withdrawn from me and forfeited my AMD, that is earnest money deposited. Order has been.
They must
passed.
have given you a notice.
Lordship,
They have given you a notice prior to that.
prior to that, no notice. Lordship.
No notice given to you. Are you sure?
Only explanation was short for, and accordingly we replied to that.
No hurry, Mr. Kamal.
Tomorrow, Lordship, because within 1 week, my AMD will be forfeited, Lordship.
It's already forfeited in a way. Only
Yes.
thing is that, you see, that forfeiture order can always be set aside. That's not an issue.
No, Lordship, by forfeiting my AMD, the order has been passed to forfeit my AMD, Lordship.
Correct. That order can always be set aside afterward. That's not that you're going to decide in one day.
Lordship, but during this day, that is within 7 days, my EMD will be withdrawn from my bank, Lordship. My bank guarantee will be encased by the department.
Day after tomorrow.
Day after tomorrow. Deeply obliged.
May I please, Lordship? I like to mention item number 4.
Yes.
I paid for adjournment. My senior counsel is out of station for medical reasons. Kindly, whether we fix for after 2 weeks on 21. It is as a admission.
Have you taken the consent of the other side?
Lordship, I am for the other side.
Okay. Adjournment prayer has been made by on behalf of Mr. S. Sharma,
Yes, sir.
the counsel for the petitioner, on the ground that
He was out of station for medical reasons.
is on the ground of medical reasons. This is the matter after 2 weeks.
I
Next.
want date may fix
No need.
21 March.
No hurry.
May I please, the Lordship? I beg to mention one writ petition for listing, Lordship.
New matter.
No, Lordship. It is a
Give a date, give a date.
Lordship, can
Next.
be before that?
Sir, one contempt case, 2015. We have already complied. Did I pay for listing so that it can be closed?
Okay, okay.
Tomorrow,
Yes.
Lordship, sorry, Lordship, the last date that I mentioned earlier, the last date is on 11, Lordship.
11.
11, Lordship. Can it be early on the day after tomorrow, Lordship?
Okay, day after tomorrow.
Obliged, Lordship.
It's a leftover matter, Your Honor, and I prayed for listing of tomorrow because the lady has no water and
No?
no water. She has no water for several weeks now. And she already got orders from High Court, which was not implemented long time ago. And she's 75 years old, kind of very, very frail.
No water?
Yes, no water, Your Honor.
It's
So
a new case.
No, it has been listed and justice services have been completed. And therefore, I beg Your Honor to take it up tomorrow.
Day after tomorrow.
Day after
Tomorrow is too packed.
Tomorrow, day after tomorrow. Thank you.
Last order directed to produce the record. I will pay for some time to get the records. I have been furnished with record, but it's not the record. It's some documents that we given to me. We'll fix it.
Okay,
No,
When? when?
Let it, let it be on 18th, my lord, March. It's no problem.
Mr. S. Bora, Learned Standing Counsel for the BTC. Submits that he needs further time to produce the reports. Accordingly, on the prayer of the parties, list the matter on 18/3. An interim order passed earlier shall continue till the next week.
1 and 2 is same. 2 is on the same.
Two also same order.
May please, your lordship. My lord, I'm extremely sorry, my lord. When the matter was posted on 1st of March, my lord, I could not appear, my lord, because of my lord, my name was not shown in the cause list, my lord. I'm extremely sorry. Otherwise, my lord, notice.
So now you see, has this order been complied with? Because it says that there's a DC order.
No, my lord, that is it. That order has been complied in a similar writ petition, my lord. That I have annexed.
Huh?
But my one is yet to be complied with.
Okay.
Similar order, my lord, I have annexed.
Okay. So
And this is because of my.
yes,
lapse.
that other order is of a different person.
Yes, my lord, different person, but with
Okay.
same cause of action, similar matter.
Oh, okay. So,
Sorry, my lord, because I could not assist your lordship therefore.
okay, right. Mister,
AF Anu Mullah.
your name is not here. You're not the petitioner's counsel.
Yes, my lord. Junior, my lord, he, my lord, does not know. He has searched the case by my name, and
Huh?
my name was not shown that day.
Okay, right. Heard Mr. FNU Mola, learned counsel for the petitioner who submits that the order dated 29/3/23 passed in WPC 1758/2023 has not been complied with. Full stop. He submits that in a similar matter.
Yes.
The DC Golpara had complied with a similar direction by issuing order dated 9/11/23 in respect of Shri Manula Sheikh. Manula Sheikh. Full stop. Issue notice returnable in 4 weeks. Petitioner takes steps for service of notice upon the respondent.
Sole
Within 3 days, huh? This is the matter of the court.
Lordship, here Lordship, handloom and textile is the main
Huh?
part. Handloom and textile standing council is there. We are not party Lordship. So handloom and textile council is required Lordship.
Handloom and textile.
Lordship.
Who is the handloom and textile counsel?
Rahul Dhar.
Huh?
Rahul Dhar.
Ardhar.
Yes.
Let him come.
Lordship.
Why don't you call him?
They have not served copy.
Huh?
They have not served copy, I think.
I have served matter to the government matter. I thought matter there is no standing council of this department. Therefore, matter
So he's just saying Ardhar is been Ardhar is the
I
counsel.
inform and shall copy my.
You just call him. You'll see. After some time.
His lordship. Well, it is our stamp vendors.
Huh?
They are stamp vendors in the DC code Shipsagar manor, and their licenses renewed up to June 24. But suddenly in February
There,
27,
where is the license? Show me.
my lord, page 20, my lord, Annexer A. Page 20A and 20, two petitioners, my lord. 20A, kindly see, my lord, that's renewed up to 20B, my lord. That's it, be renewed up to June 24, my lord. And
Yes, madam.
they said,
Lordship, I'll have to take instruction.
Yes. Where is the impugned order?
my lord, page 37. And that is this order of 11 for is redundant because renewed, already renewed. Now they said that you go within 24 hours not given, my lord. 28 they asked to remove their set without any reason, my lord. And 2007 they are doing,
Renewal has been given by additional DC
yes,
to both of you.
yes. What? Our
No, you see, Mr. Counsel. How many petitioners are here?
two, my lord.
Two. So for one, for this Kalpana Hazarika,
Yeah.
it is up to June 24th.
No, no, here second also 24.
Where?
I'll show you. My lord. You just book on. My lord, page 23, my lord. 24 also 24. Both of them, my lord. And their
Show me,
photograph is there.
show me where.
Yes, my lord. Page 20, my lord, 4, my lord. 20, 23, 20, 24, 24. 82, no, punto. Up to 20. I have detail. Here, photo,
Hi, Jagannathan also.
Where is the renewal? It's not there.
24. I'm showing my love. My love, no. I'm showing my love for your convenience. 22 to second. The control. I 24 control. And 24 is there, my love. That is why they are 60. I'm sorry, my love.
If it was clear, it would have been seen.
My lord, the 20C, my lord, page number 20C.
Yes.
It is, my lord, only, my lord, there must be some more document, my lord, or my lord, the renewal, something renewed up to June 24. My lord,
For petition number 120C, 20B is there, 20B.
lordship, but
But for petition number 2, nothing is there.
nothing is there. And my lord, that, whether it is renewed like that, because already, my lord, the notice at page 26, that is earlier also, my lord, notice was given on 11/4/2023, giving time to remove vacate the place before 17/4/2023. Lordship, page 26. So earlier also notice was given.
Oh, yes.
It is not, my lord,
This
cancellation.
notice has been issued when, Mr. Counsel?
11/4/2023, my lord, page 26, because the next page is the vernacular. There, my lord, date is mentioned, probably they did not type the in
Yes,
fact,
what is the date?
date is 11/4/2023. 11th of April 2023, earlier notice.
Earlier notice, after that December, it is renewed.
My lord,
That is my case, my
we'll
lord.
have to, my lord,
And it becomes redundant.
and
My lord,
we-
kindly see page.
notice, my lord, that has not been cancelled, my lord. Only to vacate the shop, my lord.
So alternative.
License has not been cancelled. It is not regarding the license, it is regarding, my lord, to
it
vacate
is
the shop.
Stop. The license has not been cancelled.
Cancelled, my lord. So
Then-
that notice was earlier also given, my lord, on 11/4/2023. For last about, my lord, 10 months, they were, my lord, sleeping because we license has not been cancelled, only to vacate.
11/4/23 was the letter.
My lord, earlier notice.
Then my lord,
So,
this,
my lord,
the Nazir has notified this area. According they made investment. Shops, then.
Where is your representation to the authorities?
Yes, my lord, annexure, page 28, annexure F, my lord.
Page 28 is to whom? Is to the minister.
Minister, and then my lord, page 31, my lord, to district commissioner Sibsagar. So, responding that their license has been renewed and they have notified area. Now, without any reason, my lord, how can they? Their livelihood,
These
they
are
are
two
having
different-
livelihood.
Mr. Counsel, is this your property?
No, my lord,
Then
that is definitely.
what right of yours has been violated?
My lord, our setup is there.
Yes, sir, they are asking you to shift your setup. They're not selling it. They're not telling you to close your business.
Notice may be issued, my lord.
No, you first answer the question.
Fine.
What right of yours has been violated?
I have no right, but
Then-
if in place of me, somebody could defend, that should be.
Then if somebody is given, then you can come. But it's not given, then there's
But
no
my lord,
question.
my lord, petitioners they have invested a lot of things in this, in the assurance and notified areas, even
What?
now, within 24 hours.
Not 24 hours,
But
10 months
20
back, my lord, it was given.
10 months back.
Yes, my lord.
But that is then why my not again renewed and notified this area.
Yeah,
is
you
given?
see, the license to sell has not been cancelled. That is still there. Your license to set up shop is still there. Only thing they're asking you is to give you is to make your own to make your own venue or place to sell the thing.
I understood, my lord.
Yeah.
My lord, kindly see the photograph. What
Is it their duty to provide you a place?
But they should notify, my lord. Every stamp vendor is notified that you go to that place. But let them do that things. Let them do that things, my lord.
What things?
Notify just this place is inconvenience for us, so you do it.
That's what they're saying.
Not check, my lord. Nothing
Then-
said. That is the reason, my lord.
My lord, that statement is not correct. Because there the license is issued, it is there, my lord, where they will, my lord, they establish the shop, my lord.
They are
It
authority,
is
my lord.
not,
They
it
can
is
do
not
anything.
duty of the, my lord, that they will have to provide that place, my lord.
But usually it's been done in the,
My
so
lord,
that some place,
10 months back, my lord, notice was given. We ought to have, my lord, arrange his alternative shop, my lord. Now, my lord, for various reasons, because of my lord, probably my lord, for construction of some buildings and all, because they're all old shops.
Let them come with
They are-
affidavit because Nazir has notified it is our plea, my lord. Let them controvert it.
what?
They shows us that is our.
No, no, Mr. Counsel, you have got no legs to stand on. Why should they justify? You have got to say that your right has been violated.
Yes, we are all
It's not that you come to, this is not a general store that you come and I want to buy
Yeah.
1 kg of dal or
I
something.
understood, I understood. my-
Then, if you understand,
Only
why,
equitable, my lord, this is because this lady, he used to run his,
No,
my lord, they are at bureaucratic, so that they can do anything. My lord, that-
bureaucrat or
that's-
not, bureaucrat or not, that is not the issue,
I
Mr.
have only
Counsel.
equitable points of fire submission, nothing else, my lord, your lordship. Livelihood is earning, but suddenly.
in the license, my lord, it is nowhere mentioned that, my lord, they will have to provide. My lord, since place is there, they were allowed to continue. But now, my lord, that portion of land is required by the government, my lord.
Why do you require for what?
That is not clear here.
That's what, let them come with come.
My lord. No,
You please keep quiet. When you have got no right,
my lord.
Please-
Legal right
please-
is not
please just-
valid.
Yes, my lord.
no right
Only
always been violated.
equity points. my lord.
Please just sit down.
Yes,
Sit
sir.
down. So he's challenging an order of 11/4/23.
My lord, May order, my lord. First order was that, because he did not vacate again, my lord, next order within 24 hours, my lord.
So what is the latest order under challenge right now? This 25/7/23,
27 to 2024.
24.
The lordship will find page 37.
It says so.
In that order, my lord, the earlier order has been mentioned, my lord. You are hereby informed that as per the direction of the office letter number such and as dated 11/4/23, the shopkeepers and examiners were.
This is 28/2 was the last date. What has happened as on date?
My lord, that instruction, my lord, I'll have to take instruction, my lord.
Okay, right. Heard Mr. J. Barwa, learned counsel for the petitioner, who submits that the petitioners are stamp vendors who have been given the license to sell court fee stamps or what? Court fee stamps. What are you selling?
My lord, stamp, my lord, send it stamp, my lord, e-stamp or.
Okay, who is selling
Court fee-
stamps?
Court fee, my lord.
Who are selling who are selling e-stamp, paper,
Paper
court fee stamps,
Yes.
etc.
and paper.
He submits that the petitioner's license is valid till June 2024. However, the office of the district commissioner Shiv Sagar has, by the impugned order dated 27/2/2024, directed them to remove their shop, which they had been occupying temporarily inside the district commissioner's office premises. The petitioner's counsel submit that unless alternative arrangements are made by the office of the district commissioner, the petitioners have no way to go. Next part. Miss
You does
Udas appearing for,
state additional senior government advocate Assam.
appearing for
Government of
all the
Assam.
respondents or what?
2 and 3.
Appearing for the respondents number 2 and 3. And Miss G Hazarika for respondent numbers 1. Submit that the petitioners had been given notice way back on 25/7/23.
Twenty.
11.
No, 11/4/23.
Lordship.
That is that page.
Lordship will find at page 26.
11/4/23. To vacate their place of business, which was inside the premises of the deputy commissioner's office, and to before 17/4/23. However, the same not being done, another impugned notice dated, however, another order dated 27/2/24 was issued to them to remove their shops by 28/2/2024. She submits. No, the learned counsel, next para, the learned counsel for the respondent submit that the impugned order dated 27/2/24 has not cancelled their license to sell stamps and has only asked them to vacate their place of business, which they have been temporarily occupying. She submits that no right of the petitioner has been violated by the impugned order dated 27/2/2020. I have. How much time do you need? We cannot just allow you to continue. How much time do you need to go out?
My lord,
We'll think of that. You see, it's not a case of allowing you, issuing notice and giving a stay order and that you stay here forever. It's
my
not that.
lord,
How much
only,
time do you want to leave?
yes, ma'am. Only thing is that they should not allow us, means each time is come in December and they allow us.
Huh?
Each time 23 December, each time started, my lord. So when they gave assurance and notified, then also we invested, my lord. Now, man, they cannot, they should,
These stamps are all done by your, you just need electricity.
Yes, my
no,
lord.
no,
That's
my
all.
lord, we have to open an accounts in Stock India Limited, my lord.
So how does that matter?
Now suddenly, my lord, all stamps we cannot sell. So there is financial burden. My lord, things that,
When do you, how much time do you want to move?
my lord, let them give, if we are in that position to give an alternative place, we should sit there.
Oh, yes,
That instruction will be
Partition
done.
of license.
And if otherwise they have not done, your court will decide. As of now, some protection may be given.
No protection. That matter, no protection. Right, you should, but you have got to think, why don't you think of
My lord,
something, because
my
they're selling stamps, they need, the lawyers need also.
My lord, if the license, my lord, there is no such condition that we'll have to provide the shop, my lord. It's like, with all respect, my lord. Now, my lord, electronic e-stamp vendors are, my lord, my lord, sitting like a shop, my lord. It's a shop only, they will have to open. And my lord, there is no such.
But what
condition.
is being done in other districts? Everywhere,
My lord, that is not,
huh?
not.
In
no such-
Guwahati, what's it being
Yes,
done?
yes, there is in campus.
In the campus is being given.
No, now, my lord, in DC office, my lord, it is not within the campus, my lord. Now, in the
Okay.
present, my lord, it's,
Campus.
there is, maybe, my lord, some shop, but it is others outside also, my lord. It's a like, my lord, shop, my lord, like other shops, my lord. There is no charge, only, my lord, with a computer and a printer, they will sit, my lord, and they will go for, my lord, in every area, my lord. They're specified, my lord, not specifically, my lord, the government need not have to, my lord, provide the shop, my lord. It is license is given and they can open anywhere. In all area, lordship, in here, Ujjan Bazar area also, my lord, will get a shop.
There are shops there also.
My lord, in the Kahilipara, in the, my lord, everywhere, my lord.
In
Yes.
in
East
Hangrabari
Bengal
district
is
of
there, my lord. In Eastern vendors are there, everybody knows that.
in Hangrabari, my lord, second
Everybody also, my lord, in outside, my lord, it's
Yes,
not
yes.
within that.
DC office campus, all district there is.
It is not conditioned in the, my lord, license, that we'll have to provide them the shop. Space was there, my lord, that's why they, my lord, opened the shop. But now land is required, my lord.
Tell me what right has been violated? That's the problem. You show me what right of yours has been violated. What is to be done in these type of matters from the bar? What is to be done? What's given?
Provide, my lord, of the record, yes, some drugs sometimes so that they can, my lord, 15 days time so that they can find out alternative place for to seek the shop, my lord. It's, my lord, of the record, my lord, lordship. But otherwise, my lord, there is no condition in the.
You have not filed, you have not submitted any representation to the authority subsequent to that 27-2 order.
Lordship.
My lord, it is filed, but it is my mobile, my lord. It is
Huh?
not. Because time is short, that is why it is in my lord, mobile, my lord, WhatsApp mobile. I can file.
Okay, you submitted, you
Yes,
submitted.
representation submitted.
You said, when did you submit?
My lord, my lord, on 28, 28.
On 28 you submit.
I
Then
can
you filed this writ petition on 4th March. Why did you put it here?
Lordship.
28, my lord. They sent me only on before filing. I filed in 28, my lord.
They have
Why didn't you
signed the
put it here?
I have
affidavit.
filed 28, my lord.
This writ petition 28,
Filing number is there, my lord.
2nd March.
Second
The
March.
affidavit is signed 2nd March.
Second
Second
March.
March, that, my lord. He
Third
must
March.
have come here, my lord.
And
But
yes,
they have submitted, my lord.
anyway, okay, right. Right. Just before what the government council says, just as the petition council submits that the petitioner had submitted a representation to the district commissioner Sivsagar on 28 to 2024.
I mean,
However, the same has not been considered by the authorities. Full stop. Let's go. Let's continue. Huh? I have heard the legal counsel for the parties. On considering the fact that the petitioner's counsel has submitted that a representation had been submitted to the district commissioner's office, Sipsagar, which has not been decided till date. This court is of the view that the district commissioner should examine the case of the petition, should examine the petitioner's representation dated 28 to 2024.
I'm sorry, my lord. This says that 3-4, my lord.
My lord, there is, my lord, because it is not on lordship's record, my lord, we do not know how, my lord. It can be, my lord, only on 3rd, my lord, they have, but filed on this case, filed on, my lord.
Second affidavit on
They have
second.
no legal right, my lord, violated, my lord.
This 29,
He has signed the affidavit, my lord.
29, my lord.
My lord,
So-
he is in confused, my lord.
Let it
Still
come in
mobile.
Friday, I will give an additional affidavit. And next,
My
if
lord.
there is a problem, my lord, I am not submitting wrong, my lord. Because
But you see, what is your right? I don't understand.
rights, my lord, but livelihood, my lord, equity points, I am just praying, my lord.
I'm
If
sorry, my lord.
Your license is not cancelled.
my,
Only you have been asked to move from the government premises. That's all.
so alternative arrangement, if they cannot make, then I have to leave it.
Okay, I'm disposing it off, dispose of.
Lordship,
Pass the order later.
lordship. Deeply obliged.
Yes. Hmm?
Typing at 16.
My lord, I have just been handed over this. My lord, let this matter come up tomorrow, my lord. I could not go through even the petition, my lord.
What, 16? We have got so many matters tomorrow, Mr. Counsel.
I'm leaving it to your lordship. My lord will fix any date, my lord. But
No, let us hear him, let us hear him, since you're here. Let us hear him. Let us hear him first. Yes, what is your case?
Yeah, my lord, pursuant to the tender, my lord, I have participated in the tender process, my lord. And in the said tender, my lord, lordship, important clause, my lord, 13P, kindly see, my lord, at page 42, my lord.
Page 42, yes.
Page 42, 13P, my lord. That is, my lord, terms of tender, my lord.
Page 42,
Page
yes.
42, bottom, my lord, 13P, work completion.
13
13P.
P, yes.
Work completion certificate for minimum amount of rupees 50 lakhs only during last 3 financial year from the competent authority as experience of supply of loans and accessories in different department of central government, state government should be submitted. There is a experience certificate is required, my lord. And my lord, another clause is there, my lord.
What is wrong with this clause?
Here, my lord, this clause is all right, my lord, but there is another clause, my lord, at page 35, my lord, 3E, my lord.
35.
Page 35. Page 35, relaxation clause, my lord, bottom, my lord. 35 CE,
Yes.
my lord. Relaxation for micro and small enterprise MSCs. As per the government policy circular number dated issued by the Office of the Development Commissioner, MSME, Ministry of Micro, Small and Medium Enterprise, Government of India, micro and small enterprise MSCs are exempted from prior turnover and experience in all public procurement subject to the meeting of quality of the technical specification. The bidder need to submit up to date copy of certificate of registration of micro or small enterprise with them registration certificate issued by Ministry of Micro and Small and Medium Enterprise MSME, Government of India. Moreover, the bidder must be genuine manufacturer of handloom and that clearly mentioned in the Udyam registration certificate in case MSC payment of EMD and bid costs are exempted as per government notification. Here, my lord, petitioner before lordship is my lord, page 48, kindly say, my lord, MSC, my lord, page 48, my lord. This is my
MSc.
certificate, my lord. I have Udyam certificate, my lord, so I am entitled for, my lord, that exemption, my lord. Page 48, kindly say, my lord. This is Udyam registration certificate, my lord. I'm a registered, my lord, enterprise under, my lord, MSc, my lord. So that, my lord, the relaxation of that clause is required to be, my lord, get by the petitioner, my lord. But while
No, Mr. Counsel, you mean to say that you are a small scale industry?
lordship,
Okay, so
accordingly, my lord, I have applied, my lord, but in the financial bid, my lord, in the technical bid, my lord, I was disqualified, my lord. Can you
on
see-
what ground? On this ground?
On this ground, my lord, 13P ground, my lord.
On the ground of CE.
On 3E relaxation was not granted to me, my lord. On the ground of 13P, my lord, I was rejected, my lord.
That the price, prior turnover and
Yes,
experience.
my lord, yes, my lord, on that ground.
Okay,
Uh,
so how do you prove that you are a small scale industry?
Lordship, my lord, Udyam registration certificate is there, my lord, as per, my lord, relaxation clause, my lord. I
This
submitted,
Udyam certificate was issued when?
is 2024, my lord.
Huh?
24,
When?
page 48, my lord. Page 48, my lord.
When was it issued?
Date of Udyam registration 3/01/2024, my lord.
And when was this NIT issued?
NIT, my lord, 11/1/2024, my lord.
11/1.
2024.
Yes,
And my ground of rejection, kindly see, my lord, at page 54, my lord.
page 54.
Page 54, my lord.
Yeah.
Share number 15.
Say number 15.
Share number 15, Jinko Enterprise. Document submitted but not in conformity as per clause 13P, my lord.
Page 42, that one.
13P, my lord, that is, my lord, page 44. That is my case.
So this was not required for a small scale industry.
Lordship. my lord. That
Yes,
was not correct.
so that's what Mr. Abdul, that's all. His case is basically that this 13P is not required for a small scale industry. But on that very ground, you'll have disqualified it. It's a two bid
To be
tender.
technical and financial.
Okay, right. Heard Mr.
K. Barua.
K. Barwa, learned counsel for the petitioner who submits that the petitioner participated in the NIT dated 11/1/2024. Full stop. The petitioner's bid was disqualified at the technical evaluation stage on the ground that the petitioner did not comply with clause 13 bracket P of the NIT or of the NIT.
NIT.
Full stop. He submits that
My lord is passing any interim order, my lord. That is why, my lord, I wanted the matter to be, then my lord will record this.
no,
That I am just handed over this petition right now and I ask for.
no, when is that? No, we have to do it because now technical financial bid will be opened.
My lord, he should have given me a copy yesterday, my lord, while filing. I am a standing counsel of this High Court for the last 5 years.
Okay, tomorrow.
Tomorrow, my lord.
We'll not give, we'll give us the order, but then tomorrow we'll list it.
My lord.
And then we can either vacate it tomorrow also. Right, whatever. He submits that. In terms of clause 3 bracket E of the NIT, a small scale industry is not required to submit documents in terms of clause 13 bracket P. Full stop. However, as per the minutes of the technical evaluation committee dated 11/1/2024.
That is
The-
22/02/2024.
No, where is that? Serial number?
Page 53, my lord.
Huh?
Page 53, my lord, minutes of the technical evaluation committee.
I know, where are you?
I am, my lord, at 15, my lord.
15.
15, page 15.
Did it so and so? The petitioner the petitioner's technical bid has been disqualified on the ground that his documents were not in conformity in terms of clause 13 bracket P. Full stop. Has the technical bid been opened?
Lordship, my lord, technical bid has opened, my lord. Yesterday was the date fixed for, my lord, opening of initial bid, my lord, but I have no instruction, so far, my lord, my instruction goes, my lord. Due to some reason, my lord, financial bid was not open yesterday, my lord, but I'm not sure, my lord.
Okay, full stop. The petitioner's counsel submits that to his knowledge, financial bid has not been opened, though it was to be opened yesterday. Full stop. List the matter tomorrow. In the meantime, no letter of acceptance / indent or work order should be issued.
Till tomorrow.
Till tomorrow.
Till tomorrow.
List the matter tomorrow. Tomorrow, day after, when do you want?
My lord, I have no, tomorrow, because it is better for him, my lord, the earlier.
Earlier for you, huh? So that we can dismiss it tomorrow.
Both the sides is anxiety, my lord.
Deeply obliged. Obliged.
Petitioner pass over this matter for 9 days. Senior counsel, Mr. I. Chaudhary is on bags in other.
Huh?
He's got a private respondent. Lordship, here my part at least, is yet to be.
What is their case?
Yes, but regarding, my lord, settlement of, my lord, IMFL off licenses by the excise department pertaining to Lakhimpur district.
So you,
I participated in a particular location number 5.
NIT dated
NIT is dated, my lord, 2012.
2012,
Yes, 23.
2012, 23.
23.
For, where is it page?
Well, yes, Lordship will find it at page, my lord, 26, 25.
Page 25. And for which?
My lord, it is location number LKP5. Page, my lord, 28. LKP5, Pohumora.
Okay. So you participated here
I
then?
participated, my lord, total 5 bits were there.
5 bits then?
Yes, Lordship may kindly turn to the, my lord, minutes at page 67.
67.
Yes, sir.
Yes.
And relevant will be, my lord, so far as this particular LKP5 is 69, page 69. It starts from serial number 12 to 16. page 69. Serial number 12 is the petitioner. 14 is the private respondent number 7, who is the valid bidder, and who has been allotted the ballot
Page
particular.
69.
69.
There's no pagination here. You forgot to paginate.
But it's in the middle of the page.
From 67, it's not paginated.
Why-
67, then it's which one?
69,
The,
yeah.
serial number?
12. 12.
Serial number 12. Serial
And
number
14 is the
12.
ballot respondent number 7.
14 is R7. Petitioner. Okay, then petitioner is 12.
Yes. Well, so far as the respondent number is concerned, my lord, we have found that, my lord, on verification of this particular minus of the technical bit, that, my lord, similar situated, my lord, other bidders who have participated in different locations, my lord, they have been rejected on the ground that, my lord, they have not submitted the GST registration, sale tax clearance and all,
No, forget about that. Let's stick to you.
my lord.
You cannot fight a case.
So I'm just,
We-
my lord, I'm not a stranger to the process. I have participated.
No, you might have, you
Yes.
might have.
My
But
part,
the thing is that unless you are qualified to be considered,
my lord.
you cannot make a challenge to others.
No, my lord, it is the unsuccessful bidder who will come before this honorable court. not
Correct,
the
correct,
successful bidder,
correct,
of course.
correct. First, you have got to show that the disqualification or non-selection of your bid was wrong. Then only we'll go to the next step. Let us, so there was a two-bid system.
Yes, 2 bits, madam.
bit.
I failed in
So
the technical.
you failed in the technical.
Technical bit.
Now, are
No,
you
no, it's
challenging,
technical
are you
bit.
challenging the
But that I
failure?
cannot, my lord. Lordship may kindly see page 69. For a moment, I have annexed certain documents, but I cannot, my lord. My lord, in
No,
one point.
let us go. Why, how did you fail in the
Yes,
disqualification?
Lordship may kindly see page 69.
Yes.
So far as, my lord, the first is concerned, my lord, 69, for point number 1, distance criteria not mentioned as per annexure A. That I can point out, Lordship may kindly see page 70.
Then the error in site plan.
Yes, page 76. This is annexure A of my bid.
Huh?
76, my lord. Down below distance, my lord.
Yes.
Column, my lord, para 18. I have mentioned the distance, otherwise. There is a, my lord, place of worship. It is 210 kilometers. I have, my lord, given the, my lord, distance. But despite that, it has been rejected. Now, my lord, coming to the next point.
But then aren't you supposed to give distance of all the places? What about hospital and?
No,
and-
whether it is, if it is, my lord, if there is no such, my lord, places nearby, then I need not, my lord. It's not that, my lord, in
Okay,
every
okay.
location, there will be a
Okay.
school, there will be a, my lord, place of worship.
That is one. Then number 2 is?
Number 2, my lord, there was a apparent error in the work site, my lord, in the site plan.
So this is correct.
This is correct, my lord. Instead of, my lord, being in the right side, the executive engineer.
So you made a wrong
Yes.
thing. Okay, then
That part. And, my lord, regarding the, my lord, revenue clearance certificate, that it was there.
submitted land revenue receipt.
Yes. No, my lord. Land revenue, instead of the land revenue clearance certificate, it was there. I have annexed it. Even I went to the office and I pointed out.
Okay,
to the
so
office,
land revenue clearance
but
certificate.
that
was
will
issued.
not help me because by one, my lord, ground I am out.
Because that error in site plan you are out.
Yes, my lord. I have-
Now the question arises
78, my lord.
as to whether if you are disqualified and you cannot be given the license,
No, then
Can-
we will have to
can-
go for, my lord.
can you challenge
My
the
lord, if
giving
you
of
argue-
license to
if-
another?
If in the tender process where I have participated, if they, my lord, arbitrarily reject me, my lord, here, my lord,
It's not arbitrary.
even, my lord, then, my lord, arbitrarily somebody is allotted. Am I not, my lord, I don't have the right to.
I
point
don't
it out.
think so. Not as per Ronak International. Ronak para 27, I think. That's what they're going to say.
My lord.
In fact, they're going to read out that particular one sentence. Only one sentence.
But even then, my lord, can illegality be, my lord, even if it is pointed out? Of course, my lord, the other side can point out the reasons, my lord, why the respondent number 7 has been given the offer. But that will have to be bona fide, my lord. Some, my lord, ground.
Supreme Court.
But even
Supreme
then, my
Court.
lord,
Supreme Court. I have a High Court single bench.
But, my lord, one thing, my lord, in fact, in Silpi construction and more probably in Silpi construction, it was laid down by the apex court that, my lord, the private respondents and or the petitioner, if they can point out, the honorable court will definitely look into the issue. They are the one who are the, my lord, technically they can show out the lacuna.
You see, but then in that case, at least they still have a right to to be selected. Here you've got no right to be selected. You're not going to be selected anyway. You're disqualified. Only once you have passed the test, that first hurdle of saying that your disqualification in the technical bid stage was wrong and is not borne out by the record,
Right.
and that you have a right to be considered for being given the license,
No, even my
then
lord,
only you can make a challenge.
but my
But
lord, one thing, my lord, in Honorable Supreme Court, in the case of BS and Joshi, it has held that, my lord, if a particular clause is relaxed for a particular bidder, it will have to be relaxed for all.
no, that
No, my lord, there are five, I
so
guess 5 points.
that
I
way,
pointed out.
even Poddar says that essential conditions can be deviated from, provided
It
that it's
cannot
given
be-
to
but, my lord, it
everyone.
cannot- It's not that, my lord, for one bidder it will be
Correct,
deviated, for other it will be a strict, my lord, condition or a
Correct.
mandatory condition.
But then,
That's why we have
but
pointed out.
is that your case? Yeah,
Yes, my lord.
with regard to this error in site plan.
So site plan, my lord, of course, I cannot say.
Then,
I cannot say,
then-
because apparently I know. my lord,
because there are three grounds on which you have been
because tomorrow
disqualified.
if they go for inspection, they will find. it
Then
is the other side.
that's
They
what
have
I'm
to
saying. If there are three grounds, two grounds, okay, accepted. That you have
No,
got
even
a,
I'm not praying, my lord. I should be allowed.
that's
I cannot
fine.
pray, my lord.
If you had prayed and if you had
But my lord,
proved,
whether it, bidder, my lord, who doesn't have to do, who does not fulfill the criteria prescribed in the tender condition, like me, my lord, he will be given a, my lord.
we do not know. That is
That is
that is
that
your
can-
allegation. We whether we can go into those issues from a person who cannot be considered.
But even
This
then,
is
my
not a
lord, when-
PIL. This is not a PIL.
No, not a PL, but I'm appearing before a court of equity, my lord. If the equal treatment has not been meted out, why not, my lord?
Everyone should be kicked out. No one should be given.
No, they can go for fresh, my lord, fresh. My lord. That's my, at least
Okay,
let them
okay.
reply, my lord, to the 5
What
points
was
I
the, what criteria did he not fulfill?
My lord, here may I point out, my lord. I can point it out from the minor system, my lord. Lordship, you may kindly turn to page 70.
Page 17.
Yes, serial number 19.
70. 70.
The
Problem is
the
no,
next page, my lord,
the next page. Okay.
I apologize.
Just 67, 68, 69, 70. Okay, serial number
19. Parties are
19. Yes,
concrete in the
Yes.
way. My lord, the fourth point.
yes.
The annexure A filled in original bid document. No separate application has been found as per annexure A. In the, my lord, case of the, my lord, respondent number 7, he has filled it, he has given a form filled up, my lord, fully filled up annexure A. But the separate application, which is part of the bid document, that has not been given. So here it was rejected, he was allowed. Next, my lord, Lordship may kindly turn to page 71. Next page, my lord, immediately next page.
Hmm.
Serial number 3.
I'm sorry to interrupt, madam. Perhaps there is some confusion, madam. Respondent number 7 is not Parida.
No.
No, he's saying that
That bidder was rejected, respondent 7 has been allowed.
point number 7 is allowed. Okay.
My lord, will kindly turn
No,
to next
we
page.
cannot go into those issues. My hands are tied.
Well, in that case, Lordship will take up on Thursday, at least let me have, well, if I can find something that petitioner like me has also got the right, I will place some authority. Well, only on that point, I won't argue on that point. If I don't find the authority, Lordship will. I have passed it. But my lord, these are apparent, my lord, if they can reply at least, my lord, to that point. How can the? my lord,
Why should they dry their dirty linen in the courtyard in the sun for the whole world to see?
My lord,
When you cannot, bypass the first hurdle, when you can't cross the first hurdle, why do you expect them to dry their linen in the dirty linen in the courtyard? Why should they?
but even then, tomorrow if it comes out, that my lord, illegal person has been.
That's a different issue. That's a
not the,
different
my lord,
issue.
Purpose of the, my lord,
That's a different
holding
issue,
a, my
but
lord,
you cannot do it.
open competition, man.
You
cannot
cannot do it. That's the problem.
Then on Thursday, my lord, at least if something, my lord, comes up, I will place it.
You
Otherwise, my lord,
see,
nothing.
we
These are the points, my
are
lord.
we are very pressed for time. Mr. Gogoi, you know this bench, very pressed for time. We keep on adjourning it just for waiting for you all to get some judgment.
No, my
Just
lord,
because you cannot convince the court on the first day, then what will happen? It will never end.
only for one day, my lord. I will not argue if I don't have a, my lord, judgment. Only without the authority, I will argue that. Because these are the
Right.
points of my main.
Heard,
Why
yes,
is that-
Mr. I think that's the only thing. Heard Mr. B. Gogoi, learned counsel for the petitioner, who submits that he participated in the NIT dated 2012-23 for the IMFL retail off license pertaining to shop
LKP
number
LKP
LKP5 for Mora, Lakhimpur district. The petitioner's bid was disqualified at the technical bid evaluation stage. Right. Technical bid
17
evaluation committee meeting held on 17/2/2024. Next para. The petitioner's counsel submits that though though the petitioner's bid had been disqualified, technical bid had been disqualified on 3 grounds, 2 out of the 3 grounds were not in terms of, the 2 of the 3 grounds for disqualifying the petitioner's technical bid was wrong and not justified. However, he admits to the fact that there was a error in the site plan submitted by the petitioner, which was one of the 3 reasons for disqualifying the petitioner's technical bid. The petitioner's counsel submits that though the petitioner cannot cross the hurdle of qualifying the technical bid evaluation stage, the grant of the IMFL retail off license to the respondent number 7 is illegal in as much as the respondent number 7 had also not fulfilled all the conditions required in the NIT dated 2012-2023. He accordingly submits that the license granted to the respondent number 7 should be set aside and a fresh tender should be issued. Next, Mr. Indrajit Chaudhary, learned senior counsel for the respondent number 7, and Mr. K.P. Pathak, learned counsel for the excise department, submit that the petitioner not having qualified in the technical bid evaluation stage, he cannot make a challenge to the grant of license to the respondent number 7. In terms of the judgment of the Supreme Court in Ronak International Limited versus IV Construction, IVR Construction, that 1997 over 1999, 1 SEC 492, where it has been stated at para 27 as follows. Therefore, any judicial relief at the instance of a party which does not fulfill the requisite criteria seems to be misplaced. Inverted commas first. The above being said, Mr. B. Gogoi prays for one chance to produce citations in support of his submission. Leave the matter on Thursday. We'll give one chance. If you cannot bring, then that 2-3 lines of this order will go and it will remain.
He has to Place a judgment overcoming wrong.
My lord.
Yes, yes, that's what. One chance.
Need preacher laws.
Yes.
But bit interesting issues before your lordship, Milord.
Are you covered by this, Ronak?
No, not at all. A little bit different, Milord.
Okay, yes.
Milord, by Water Resource Department, Milord,
Yes.
I did notification, NIT notification dated 17 January at page 43, Milord. Issued 44 numbers of site for various work under the tender. And I am interested in point serial number 5 at page 43.
Page 40?
3. Nothing is, there is no problem, nothing I am qualified to participate. But there is a point in NIT, in the tender document, that is at page 54 and 58, Milord.
Page 54 and 58.
54, Milord. Page number, point number 4. Qualification of the bidder. As your lordship seen it.
Yes.
Then next page, Milord, will see kindly small k.
Yes.
Site visit verification report issued by the executive engineer has to be mandatorily submitted along with the technical bit. And the same point was enumerated at page number 58.12p. Same point. Now, my lord, there is no prescribed procedure prescribed in the tender document or in the NIT how to obtain this site verification report.
You have to take it from the concerned engineer.
Yes, sir. No, but there is no written procedure is not prescribed.
So
So,
you go and ask.
no, I went.
Then he didn't
Then
give you.
they did not. Then I have annexed documents that I priorly intimated, Milord.
What is the last date of submission?
27. I submitted, Milord.
Oh, you submitted
I submitted without that document because they refused it.
27/2.
Yes. And on 29, they have rejected my bid.
27 to the last date.
Last.
And 29,
29th, they have rejected my bid.
it's a 2-bit system or a
Two bid.
29, 24, a technical evaluation stage.
Yes. They said that I'm not technically responsible. Technically non-responsive. That means there is a flaw in the technical bid. The flaw is only that the certificate to be issued by the executive engineer. This is not the first case, Milord. Earlier in another issue, another spot, Milord, and the same notification, they refused to give us the executive engineer refused in Bozali district. There was some time in our hand we approached this court.
Why didn't you approach this court earlier?
No, Milord, I thought after that order by this honorable court, they would give the certificate. Because
In this case? No,
well, there are many spots. There are many locations. In one location is Bojali, this is in
this is a
Vishwanath.
so this appears to be a disputed question of fact.
No. I have annexed documents, Milord.
Yes, you show me.
My lord will come to first, Milord. Will come to page 105, annexure 6. This is an email, Milord. I sent to the executive engineers on 23rd February 2024, attaching a letter, my lord. Next page. And expressed our intention for site verification. It's page 106, letter dated 22. Then, my lord, we did not receive any.
Just a minute. Where is the NIT?
NIT has page, my lord, 43.
43.
Yes.
43 had.
And lordship will see the tender document starts at, my lord, page 46. Tender document start at page 46.
Yes,
Then, my lord, on 23rd February, we have intimated by a letter dated 22 February. We did not receive any response. Then we have again on 26th February, again written a letter and sent our person there too. That is that lordship can see at page 107 and 108. Then our person visited the executive engineer's office. Lordship can see at page 109 with all Google Map locations. There are two photographs. 109 and 110. We have visited with all Google Map locations and we have taken this photograph. Now your lordship asks why you have taken this photographs. Because on last occasions, my lord, the lordship can see I have annexed that order of this honorable court, coordinate bench of this court at page 117. This question was asked. There is no proof that you have visited this site. Even then, this honorable court was pleased to give us an interim order and this matter is closed. Your lordship has passed that closure order because we have given this certificate and we have participated in the bid. Now, my lord, on this, in this particular case, they again refused, though the division has difference. But this is a modus operandi of the whole department, my lord, to create a syndicate so that they can offer to the job to their person of choice.
But you had all the time in the world to come to the High Court.
No, my lord. My lord, kindly see, when we have got the time, we approached. This honorable court gave us the relief from interim orders. Now, my lord, we thought that since this has been circulated to the department, we thought that they will not do the mischief again. So, my lord, this time we approached the department again asking for the certificate. And kindly see, what is the logic of this condition? There is no point of giving this. On one hand, they used to give this.
No, there must be a reason.
There is.
There can be a reason so that you know what you're going to go into. And
Yes, my lord. That is what I have given a statement because I am my petitioner, my lord. This petitioner is an experienced worker contractor in this line.
No,
Yeah.
but you see, but there are many cases where they get settled with the mahal or whatever, and then they say there's not enough sand, not enough this,
No, no,
not that.
but what
It
I'm
happens.
trying,
So maybe
what I'm
because of
trying to
that.
say to your lordship is, if somebody does it quote a rate without going for a site verification of their own, they do it at their own cost and risk. Now, my lord, I have visited.
I don't know. Anyway, yes.
His petitioner had earlier also filed the cases.
Sure.
Earlier also filed, and if your lordship.
Earlier file a case.
Yes,
Which case?
That I said, my lord, I have annexed the order.
Not
Oh, then you know, then you know then if you know that this will happen again, why did you wait?
No, my lord, that is what I have explained, my lord.
in WPC 983 of 2024,
Hmm.
that is, they have challenged the same tender notice, but
Same
they-
tender notice.
same tender. That is, their work was number one, where it was specifically, the number one is the same work that now the petitioner has challenged. This is of Bazali, now is in this one, in
Wait,
Vishwanath.
just a minute.
District is different, Lordship.
Serial number 5 now.
Serial number 5, Lordship.
Right now, serial number 5.
5. Earlier, it was serial number 1.
Okay, so they knew.
Yes, Lordship. They knew that last date and time of opening of the tender. Or for serial number 1, they have approached the Honorable Court and the Honorable Court had directed them. And Lordship, interestingly, Lordship, if the Lordship goes to the certificate which the concerned executive engineer of Godali had given to them, and they have received also, where they have stated in the certificate that they have the first time they have visited the office of the executive engineer. It's clearly reflected.
But
In
it is-
this case also,
I don't
they
know what
have-
is that certificate, but this is in.
no, this
as
is the
regard to-
certificate that is received by the petitioner, Lordship.
No, no, no,
This
this
is
is
the
as
receipt-
regard Bazali, now it is Vishwanath. my
No,
lord.
Vishwanath is also
No, my
the
lord,
same.
my respectful submission, they cannot sit over of their own mischief, my lord.
No, Lordship, this is not,
This is the
is
mischief,
not true, Lordship.
this is the modus operandi to create a syndicate.
no, Lordship.
I
nothing
have,
is there.
I have
Lordship, if
reduced,
that be true,
well, let him come up on affidavit
Lordship,
that my
I will-
person
I
did
will,
not
Lordship.
visit.
No, they have visited, Lordship. They have visited the office of the executive engineer, but they have never visited the site where they have to
Oh.
execute the work, Lordship. The executive engineer.
My lord,
asked them-
executive engineer
Lordship.
asked my officers,
Yes,
my
Lordship.
my person that no need of
You see,
visiting
the
this site.
problem is what you're submitting is basically questions of fact,
Lordship.
which this court cannot decide.
No, my lord, my respectful submission.
And if that is the.
My lord, there must be some plausibility of something. I have visited the office. My friend has fairly admitted that I have visited the office. Is there any point that I will not visit the site?
Lordship, during their visit.
My
to
lord,
the
kindly,
office-
kindly, how can my learned friend overcome my two letters? The
Lordship.
letter dated 22 and 26.
Lordship, during their visit to the office of the executive engineer Vishwanath, executive engineer had requested them to visit the site so that later no complications arises. During their visit, they are just calculating the time. They are asking the executive engineer how much time it will take from the office of the executive engineer to visit the site. When
My
the
lord-
executive
my lord will
engineer
kindly
informed them,
say-
then it will take another 1.5 hours. Then they are calculating that it will be take 3 hours. It will be late for them to coming to down.
My
to
lord will
Guwahati.
see, my lord will see the
As per my
timing.
telephonic instructions.
Kindly, my lord.
Otherwise, I will file an affidavit, Lordship.
My
Next-
lord will
next
kindly,
week, Lordship may
my
fix
lord
the-
will kindly come to the, come to
And
the.
moreover, Lordship, if Lordship turns page 113, which my learned senior had annexed.
My lord, will- my
regarding
lord will,
the
my lord will
rejection
appreciate.
of his tender.
Ek minute, 1 minute. My lord will kindly come to page 110. Kindly see the time of these photographs. 110 minutes.
No, I'm not on
Just
that.
kindly allow me to
No,
submit.
no, please understand, please hear also. You see, we are hearing you the whole day. You see, one thing is you had an experience of not being provided a certificate earlier. And that's why you filed a case before this court. With regard to the same NIT,
Same NIT for a different location.
for different location, but you knew that this sort of thing happened according to you.
My lord. No,
So
how
why
can I
didn't
know
you
that
file a-
Vishwanath division will do the same thing, my lord? I approach kindly see, my lord.
Lordship, the closing date is same.
No,
On
no, no, that is
15th,
it.
that is the-
How can he overcome the
24.
mischief committed by his client? No,
Mr. Counsel, there's one thing, this is a disputed question of fact.
this is not
The-
disputed, my lord. Let me explain how, my lord.
Huh?
It is not disputed, my lord. Kindly appreciate for a while. They cannot take away the rights of the citizens to participate, equal opportunity to participate in business, my lord. Kindly see, these are government tenders.
Maybe, just a minute.
For the timing, lordship may issue a notice and they will not finalize the tender, my lord. That is the
No,
only prayer I have made, my lord. Because otherwise there will be a
objecting to
third
the
party
prayer,
right
Lordship.
created, my lord.
Lordship, I am objecting to that prayer, Lordship.
There will be a third party right created, my lord. Kindly see. Kindly see page 110. I arrived the office on 10
Lordship, may
AM in the morning. After visiting the site, I approached the previous page, my lord, 109. I approached the executive engineer at 2 PM. Then he said, no, we will not issue the certificate. We will be provide you some other job, other contractual work. Don't create trouble
Lordship,
for this.
Lordship may kindly turn to page 113. Everything will be clear, Lordship. Because 113, which my learned senior has annexed, that is the rejection, his rejection. Otherwise, there are total 5 numbers of bidders who have participated. Only 1 bid has been rejected. The other bids are all qualified. That is reason proper, accepted technical.
Technical, because
Only serial number 2, the bidder of this if the department has got some modus of operandi, if the department wants to favor a particular contractor, then they should have rejected the others contractors also bid. But they
Because
have
they-
accepted
because
all the
you need
bidders. What
three or
is the
four.
reason?
You
What is the reason of rejecting only his bid, Lordship? Is there any personal enmity with him, Lordship?
No, my lord will kindly appreciate the photographs, kindly see. I arrived at this spot in the office at 10 AM in the morning. Then I visited the site, then approached the executive engineer at 2 PM. Then I was refused.
Yes,
Now, my lord, I have got appearing before this court. Now I am being telephonically instructed by my client that there was a threatening that they will cancel my contractor license with this department. Because I have created this trouble for the department. This is not Gundaraj, my lord. This is a democracy. Your lordships are here. This is
You
the,
see, the only problem is, this is not a court of facts. That's the only problem. And what we are basically, a basic case is on issue of facts. I could have understood if you had come earlier, because the same thing had happened to you and you had filed a petition
my
earlier.
lord, my lord will
But
appreciate.
now,
My lord will appreciate.
same thing. Okay,
Without there being a cause of action.
please
if
lower
I-
your tone, volume.
my lord, sorry, my lord. Without there being a cause of action, if I approach, then lordship would have said you are premature.
No?
How can
How,
it be?
why would we have said that? Why would we have said that? If it's
Because
premature.
if
When
there
you
is
have
no
come,
cause of, my friend would have argued then, no, there is no cause of action. You
No.
approach, we will give you. the
then
certificate.
we could have directed, this
Okay.
just said that they're going to get,
Lordship, they have
No,
earlier approached,
my
Lordship,
lord, my
because
lord,
of which the
my lord,
Honorable Court has directed.
if lordship
Directed us.
examine the validity of this clause. If it is found illegal or without any logic,
On 22nd February, they have approached this honorable court and the honorable court has directed. And again, on 22nd February, we have issued that license, this what, certificate, Lordship, which is before your Lordship, Lord.
that is why, my lord,
this is 22/2/2024.
yes.
And
We have-
the last date was 27/2, for all.
No, the same tender which is in serial number 1 for Bozali district and the same tender which now my learned senior is contesting is tender number 5.
Correct. So in both the
Yes.
tenders, the last date was 27.
Lordship,
And in this earlier writ petition,
he has filed.
he had approached this court
Yes, yes.
prior to the last date.
No,
Now
no,
he has
for-
come after the
For
last.
Bozali, it was
Yeah.
26, my lord.
Huh?
Bozali, it was 26.
26, but then you have come, this orders on 22.
20
So
yes.
prior to the
My
last
lord,
date you
but
approached.
when this, well, how can the procedure of that, but you can influence your lordship by this?
Yeah, it's not being influenced. The question is, in the last, with regard to the other tender, you had approached this court prior to last date.
My lord, my
Now
lord,
you have
my
approached
lord,
this
my
court
lord,
after
my
last date.
respectful submission, my lord. If suppose I have, but I have approached this
I
court within a
appreciate it,
reasonable
Sharma.
time, my lord.
Learned counsel for the petitioner who submits that the petitioner submitted his bid in person to the NIT dated 17/1/2024 for award of the work regarding inverted commas is serial number 5, page 43. Construction of CESA RB sensor center, bracket phase 1. Okay. The last date of submission of the bid was 27/2/2020. However, the petitioner's bid was disqualified at the technical bid evaluation stage and declared unresponsive out of 5 bids that had been submitted. First of all the other 4 bids were declared to be responsive by the respondent. First up. The petitioner counsel submits that that clause 4 bracket K and clause 12 bracket P of the NIT required a site visit verification report to be issued by the executive engineer, which was to be mandatorily submitted by the bidders along with their technical bids. Next paragraph. The petitioner's counsel submits that the petitioner submitted an email dated 23/2/2024. To who? To who is this?
Executive engineer.
Where?
But later dated, my lord will see later dated 22nd.
It just says to whom? Where's the address?
See, email ID is there, my lord. To the executive engineer, Vishwanath Division.
Page 105, where does it say?
One of the email ID, my lord, to wrd.vishwanath@gmail.com.
What have I said? To the executive engineer.
Vishwanath WR Division.
To the executive engineer, Water Resource Department, Biswanath Division, whose email was WRD Biswanath@gmail.com.
And copy was marked on
Along with a letter dated 22/2/2024. Requesting a site verification report. Requesting a site verification certificate after representatives of the department and the petitioner inspects the site. Full stop. As nothing, as no reply was forthcoming, the petitioner sent another email dated 26/2/24 to the respondent number 3, along with another letter dated 26/2/2024 to the same effect. The petitioner's representative also went to the, is it representative? This
Yes.
photograph.
Correct.
Also went to the office of the concerned executive engineer on 26/2/2024. Requesting issuance of a site visit verification certificate. However, the same was not done. The petitioner thereafter submitted his bid documents on 27/2/2024, which was disqualified as he did not submit the mandatory site visit verification certificate. The petitioner's counsel submits that the respondents should be directed to accept the technical bid of the petitioner, even in the absence of the site visit verification certificate, which had been illegally denied to the petitioner by the respondent. He submits that in a similar matter involving the same NIT dated 17/1/2025 regarding the contract work pertaining to page 43, serial number 1, huh? The petitioner was not issued a site visit verification report by the executive engineer. However, the petitioner approached this court by way of WPC number 983/2024. And this court, by order dated 22/02/2024, directed the petitioner's representation to visit the office of the respondent number 3. To visit the office of the executive engineer Bajali. Thereafter, the executive engineer Bajali or his representative was to facilitate the petitioner's visit to site, whereupon a site visit verification report was to be issued by the executive engineer Bajali. The petitioner's counsel submits that a similar order may be passed in the present case.
No, my lord, in this case, the similar order would not do, my lord, because I've already been rejected. So I prayed for an interim protection that the financial bid,
Cut that last thing.
financial bid may not be obtained. Because they cannot have the leverage of both the sides. Once,
But this
My
is
lord-
this is a question of fact anyway.
no, no, the question of fact, my lord, I am on oath. There is no point disbelieving me, my lord.
First up, right? Issue notice. Or you take instructions. What instructions?
Nothing.
Nothing to be instructed. Nothing.
I will have to file affidavit, lordship.
Okay. Issue notice returnable in 1 week.
Lordship.
You file it within a week.
Lordship. Alright.
Mr. R.M. Das, appearing for all the respondents,
Lordship. Lordship.
submit that he will file an affidavit within a week.
Lordship.
Stop. The petitioner. No, the petitioner was not given a site verification report,
Since he has not visited the site, lordship.
as he has apparently not visited the
The
site.
site, only he has visited the office of the executive engineer before.
In pursuance to the contract was 43 serial number 1, huh? Page 43. In terms of the same NIT dated 17/1/2024, which is the subject matter in issue in the present case. The order dated 22/2/2024 passed in WPC number 983/2024. had been made prior to last date of submission of tenders. That is 27 to 2020,
No, last date is 26 in that case.
26 to 2020. In the present case, the last date of submission of tenders is 27 to 2020. And the petitioner has filed the writ petition only on 4/3/2024. The petitioner's technical bid was declared unresponsive on
29 February.
29 to 2024. List the matter on 1 week. Next one, Tuesday.
Next Wednesday, Lordship. Can it be on next Wednesday?
Next one is Parik.
Lordship.
My lord, till that, my lord, the financial bid may not be open. Otherwise, there will be again a third party right be created, my lord.
No, Lordship.
And we have to,
Nothing is
we have
there.
to make him a party, then it will be again derailed.
Because
So one thing you're right, before that it is right, the issue brought out by the petition counsel pertains to disputed questions of fact. That's all.
My lord, my respectful submission, lordship would,
They're very difficult. No, these are disputed questions of fact, Mr. Counsel.
my lord had considered my friend's submission that, my friend said that I did not visit the site. I said, my lord, I visited the site and approached the executive engineer. No, no. My lord, there is no point, my lord, to have the higher weight to his submission.
no, I am not pressing for any higher weight, Lordship. If the petitioner had visited the sites, they
My
could
lord,
have
my
annexed
lord,
some photographs.
lord, nothing
Since they
will-
have annexed the
nothing will
photographs of the
cause any
office
prejudice
of
to
the
any-
executive engineer when they have visited, but they have failed to annex the photograph of the site where they have visited, Lordship.
No,
If
my
they
lord,
have
my-
really visited the site, Lordship.
My lord, my respectful submission would be, my lord, what my,
You see, these are disputed questions of fact.
Lordship.
I'm not inclined. Next.
Lordship, here Lordship, standing council PNRD will require Lordship. Our names are shown, but PNRD names are not shown.
Hmm?
PNRD standing council required Lordship.
Okay, one thing you can write. The question of the prayer for an interim order will be considered on the next day. Okay, Mr. On the next day, depending on what instructions you bring. And if you don't file an affidavit, then I'm going to give a stay order. You file this.
One, already, the tender was already been over. If similar, in that case, it is not. I have the.
Yes,
Lordship, matter pertains to non-payment of contractor's bill, Lordship. The petitioner is a government registered contractor firm, Lordship. They had been supplying raw materials to the Bezara Development Block, Lordship. What happened, Lordship, prior to
that's
the
what I'm to yes. So what has happened?
Lordship, prior to the year 2014, all my bills were being regularly cleared, but for the period 2014 to 16, though my materials were being duly received and also the bills were acknowledged, the bills have not been cleared, Lordship.
Come on, some.
For that,
Oh,
I approached Lordship, they denied. So that is why I'm before this honorable court, Lordship,
so it has not been paid.
not been paid, Lordship.
Lordship, standing council PNRD.
Who is the standing counsel?
Yes, the same.
So what to do?
Showing their name, Lordship, will be
You
clear.
call him.
Lordship. Obliged, Lordship.
May I please your lordship, the matter may be taken after some time as Mr. Ken Chaudhary is on legs.
Next.
Wait, please, your lordship. Also, I'm seeking a week's time to file my response against the affidavit of opposition filed by response number 224. A week's time may be given to file my response.
Mr.
Mr. K. M. Mahanta.
K.
K. M. Mahanta.
K. Mahajan.
Mahanta.
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 Learned counsel for the petition is granted
A week's time.
a week's time to file
Counter.
affidavit in reply.
Yes.
This is the matter of the review.
The date may be fixed, your lordship.
18 year old.
Why is there stay order?
Yes, interim order.
And the interim is already still.
Huh?
There is an interim order, your lordship.
Give a date.
Interim
21st.
order may be continued, please.
Interim order to continue till the next day.
Please, your lordship. Okay.
This item will be passed out for the time being.
My lord, the matter relates to, my lord, non-payment of admitted amount by the state government.
Where is the admission?
Yes, my lord,
There is a direction by the honorable court to produce the record.
No, is it an admitted amount?
In the affidavit, we said that it is not, in respect of 12, they are claiming, we said we are not liable to pay 12 bills. We are like, we are only admitting 6 bills.
So you pay the 6 bills. That's not. For the others, is there any arbitration?
Paragraph 6.
no.
No.
What I'm on, my lord,
But,
the records, my lord, I'm sorry to say, my lord, in my career, I have come from the first time. My lord, page 31, my lord, will tell this. This is director, my lord, 5th February 2023, when my contractual prayer.
Yes, 7, page 31.
31 of the retribution.
Yes.
In inviting a reference to the above, I am directed to inform you that the government approves the payment of balance amount of 63 lakhs so and so amount. So and so, my lord, only to the group and media private against the telecast of TV commercial produced by Jahanu Bagwan. You are requested for putting your views regarding the balance amount left with the directorate after the payment. All payment should be done on receipt of specific original bills, not simply on certificates. All taxes and statutory deductions should be made at source and remitted to government accounts.
So 63 lakhs.
Absolutely, my lord. On different dates, my lord, they file different affidavits. They take different grounds which are contrary to records. That's why there has been a judicial order, my lord, to produce the records.
the second paragraph, they said you are requested to put in your views regarding the balance amount left with the directorate after the payment. All payment should be done on receipt of specific original bills and not simply on certificates. All tax and so and so. In the affidavit filed in the matter in paragraph 6, we have said that it is a fact that the government
Paragraph 6 of
paragraph
your affidavit.
of respondent number 4's affidavit,
Just a minute, respond number 4 affidavit.
it was filed in February 2014. By Syed Liaquat Ali.
Huh?
By Syed Liaquat Ali, respondent number 4.
No, I'm looking for the affidavit.
Affidavit in opposition.
That is dated 10/3/2014. We have received the copy. 10/3/2014, we received the copy.
This is it.
Oh,
By 4. Respondent number 4. no?
right.
Not there. Oh. Yes,
Paragraph 6, Lord.
page 50,
Uh,
paragraph 4.
Para 6, Lord. Page 3, internal page 3.
Yes,
But we said, Lord, that it is a fact that the government of Assam in the tourism department had approved the payment of the balance amount of rupees 63,09,596. But the payment could not be made as the petitioner had telecasted only 6 numbers of TV commercials. The matter regarding telecast of 6 TV commercials in place of 12 number of TV commercials were brought to the notice of the government. The petitioners were requested to submit copies of the video clippings of the TC commercials already aired by email dated 27th of April 2012. However, the petitioners informed by their email dated 16th of May 2012 that they have not preserved the video clippings, although initially they had agreed to provide the same by their email dated 2nd of May 2012. So that nothing is admitted here. No? But, and the communication from the director is that whatever is the
These are the statement being made by law, just a minute.
no, not a statement
Act-
on record. I'm
My lord,
from
these are the
record I'm
statement, my lord, I have perused the record in the open court by way of an affidavit I have brought on record. These are the statement which are contrary to records. The number of telecasted, how many has to be telecasted is in the agreement itself. And I have done my part from September to December, my lord. And it's been completed. And thereafter, bills were raised. Bills were made payments, my lord, subsequently also. And thereafter, the final bill, my lord, is been sanctioned. Everything has been done. And thereafter, the change of tourism director, my lord, and this comes in. Whatever statement has been made is contrary to records. I can show from the record, they are not producing the records. I have noted down in my affidavit and I have sworn in the affidavit before the court. Record says something else.
that we'll have to see, Mr. Counsel. Let me see. But I cannot go beyond what is in front of.
No, my lord, what the law says, my lord, one can dispute in affidavits. My lord, disputed question of facts, merely saying the disputed question of facts, my lord, which are contrary to records, will not amount to that extent, my lord, because I have produced documentary evidence with regard to this. My lord, may I take your lordship to my facts of this case, my lord?
No, you can, but I just want to remind you
Yes.
that there are judgments, which you know much more than me, Supreme Court judgments, which have categorically laid down what can be decided, what cannot be decided.
Yes, absolutely. I am within that parameters. I am within that parameters. My lord, that's why, my lord, on repeated occasions, court's order is there. Produce the record. They are not producing it. My lord, may I take your lordship to the writ petition, my lord? May I start it, my lord, pointing out one thing or the other will not help them, and neither help me, my lord. My lord, I take your lordship to the annexures, my lord, at page 15 of my writ petition. Page 15 of my writ petition, my lord. This is Director of
So,
Tourism.
the basic case is that they are supposed to telecast 12,
Yes, the material that has been provided
12
to
documentaries.
yes.
No. I'll satisfy my lord. I'll satisfy. They have not handed over 12 to us. Where is the question of showing it this one, my lord?
Those are disputed.
No. These are not disputed, my lord. I'm sorry.
Ultimately,
Only
the
because
director's
using the
instruction
word
is not-
disputed will not help. It is on record. It is on record that whatever has been given to us has to be telecasted. May I come to my lord, page 15, my lord? This is the EOI, my lord, for Imperial Advertising Agency, Assam Tourism, my lord. Director of Tourism, Government of Assam, at page 15, my lord. And third, bottom line from third, my lord, will kindly see 2nd of February 2011 up to 3 p.m., my lord. So this expression of interest from advertising agencies, what will be the requirement, my lord? That has been laid down, my lord. We'll kindly see at page 16, it continues. Qualifying criteria for agencies, my lord, will kindly see.
What is the date, EOI dated?
Yes, that is 2nd February 2011. That's in page 15, my lord.
2011 matter, okay. Then,
This was page 16, my lord, will kindly see the qualifying criteria for agreement. Agencies. 1, at page 16, my lord, will kindly see. The annual turnover of the agency should not be less than 20 crores for the last 3 financial years.
so and so, my lord, all these documents has to be annexed. The agency should be in panel advertising agency currently for at least 5 major national clients and 1 state tourism department stroke corporation of India. This is requirement. The agency should have Indian Newspaper Society INS and India Broadcasting Foundation IBF accreditation. The agency should have a representative registered office at Guwahati.
So let us go straight to the agreement. Where is the agreement?
I'll come to that, my lord. It is
No,
very
the-
important that they are saying 4 and 6, that I am in the agreement.
What 4 and 6?
With regard to the material that is to be shown, my lord.
No, the agreement will provide everything.
Yes, my lord. That's why I am taking your lordship, my lord. Can you see at page 70? The agency should have at least 10 years of working on advertising. It should have independent media planning and media buying team, provided details of man, total staff, strength and planning, so and so, so and so. Agency should not be blacklisted by any central state government, public sector, so and so, my lord. The agency should not be involved in any major litigation that may have impact of affecting the compromising the delivery of service as required under the expression of interest and in execution of the contract. Scope of work. The scope of work for the implement shall be, but not limited to the following: develop accident cost effective, innovative and strategic media plans, handle media buying and execute the campaign to maximize mileage within the set budget for promotion of Assam tourism. Selection criteria, my lord.
No, let us
yes.
not go into all those.
And my lord,
not
last line
relevant.
is very important. Last line is very important. The duration of impanelment shall be initially for a period of 1 year, which can be extended for a further period of 1 year based on the performance and on mutually agreed terms and conditions, my lord. Now, my lord, can we turn to, my lord, page 18. Now, we have submitted our documents, my lord, and this is a document with regard to, my lord, this. In response to the invited submitted expression of interest for your media campaign, we are pleased to submit the same in your prescribed format along with relevant supporting documents. Now, this has been received. The application form, my lord, at page 19, my lord, I am not troubling your lordship with regard to this. Now, at page 20, my lord, this is with regard to Assam government. Group M, so and so, issue of cover, so and so at page so and so. Now, at 21, my lord, you can see. This is very important. Invitation for financial bid for television commercials. Please refer to the discussion 14 February 2011 in the conference hall so and so. You are directed to submit financial bids involving national, international channel, NDTV, Hashtag. All the channel names are there. The slot would be 4 to 5 minutes a day, including prime time, GRP with TZ, female so and so, and the period of evolution is 1 to 7 weeks, 2000 and channel, and the channel wise band with prime time and prime ratio should be mentioned. The finance should reach the undersigned before 24 February 2011. This is so and so. This is a letter from Assam government. Now at page 22, my lord, can we appreciate in panel. This is from Assam government. I would like to inform you that evolution of the EOI and the financial bids submitted by various agencies, your agency has been selected implement for execution and advertisement campaign through TV channel only, my lord. And as mentioned earlier, so and so's dated 15 February 2008, you are hereby requested to intimate your acceptance. On submission of acceptance, an agreement will be executed after negotiation of modalities. This is 25 April 2011 at 2 p.m. Now, this agreement comes in at page 23, my lord. This is 6 September, my lord. The telecast time is for 4 months only. 6 September to, my lord. Yes, this agreement is for 1 year, I'm sorry. 6th day of September, my lord, Media House, so and so, my lord. Now, at page 23 is very important. These are the terms and conditions. May I take your lordship to page 24, my lord. This agreement is valid for a period of 1 year from the date of execution of the agreement. The second party shall submit the most ideal and cost-effective media coverage, NDTV, so and so channel, my lord. All the channel name has been there, my lord. I skipped this one, my lord. For a national campaign within a budget of rupees, budget has been fixed at 3 crores 78 lakhs 37 so and so for a phase, for the first phase of the campaigning spanning 4 months. Am I clear, my lord? That 1 year period, the first phase is of 4 months, my lord. That's been clear in this agreement itself, page 24. 4 months, ensuring maximum mileage for the campaign. So they are saying it is for 1 year, 12, this is nothing. It is for 4 years.
Huh? What 4 years?
4 months, sorry, like 4 months. That the second party shall complete execution of the first phase of the campaign spanning for a period of 4 months. The first party shall make the payment of 3 crore 78 lakh for the second party in 3 installments. It's also been agreed upon. That the first party shall release payment in second party in installment as follows. First installment 20%, 75 lakh 67,000 so and so will be paid on execution of this agreement mobilization as well. It has been paid. Subsequent payment will be made on receipt of actual bills on month-to-month basis. The last installment, the second one is also been paid. The last installment of 10% will be after the successful completion of the campaign. Now this has been withheld. They withheld it. That the second party shall commence execution of the campaign within a week of execution of this agreement and on receipt of the first installment of the payment. The first party shall hand over the original creatives of the channel campaign made by Jahanu Borua in DVD format to the second party, along with the sequence to be followed for releasing to the TV channels. So, a person, Jahanu Borua, a very reputed person, who has created this DVDs, my lord, the first party will hand over to me. The second party shall return the original DVD to the first party on completion of the campaign. The first party shall not alter media plan intermediate once plan is approved. The second party shall not deviate from the plan once approved by the first party. The first party shall not suspend the campaign once the execution is commenced, as doing so cause exorbitant cost escalation and derailment of the campaign. The next one is very important. The second party shall submit original copies of the bill received from the channel on completion of campaign to the first party. We have submitted original bill. NDTV, it has been shown. NBTV, my lord, certificates, all everything, my lord. The first party reserves the right to get refunded of the amount paid to the second party if the second party fails to comply with any of the aforesaid clauses of the agreement. That in case of disagreement between the parties, both the parties shall sit together mutually and workable solution, so and so, so and so. Now, this has been an agreement that has been signed, my lord. And this agreement is for 4 months first phase campaign. And the DVD will be provided by Jahanu Borua. Now, my lord will kindly see at page G. Page annexure G, my lord, page 26. This is from Group M, my lord. I'm not reading everything, my lord. And this is the date is very important. That is after, my lord, the completion of the whole of the 4 months period. This is to the Tourism and Finance Government of Assam. Dear Mr. Das, this has reference to our email dated so and so address.
See, instead of going through all what is the claim? How much are
Yes,
you
I am
claiming?
coming to it, my lord. I'll
There's no
come, my
point
lord.
reading the entire
I
thing.
satisfy your lordship, my lord, because here, my lord, with regard to campaign, my lord, it has to be ensured, my lord, it is been in an economic way. Economic way, my lord, these national channels, private channels, they charge a lot of money.
You see, that's not the issue. The issue is this. Yeah, basically, let's cut it out short.
Yes.
You are claiming certain amount. How much are you claiming?
My lord, the remaining amount
Where is
is,
the
my lord, balance amount is 63,69,596. And my lord,
63 lakhs,
9,000, 69,000,
9,000.
9,059.54. This is the amount.
This is on what? On what is this for?
This is for the campaign, my lord,
For
which
the
we have
campaign.
completed.
So according to them, you have to telecast 12
Yes, I'm
commercials.
satisfied that part. They have handed over me only, my lord, that this,
So
with the permission, I have
So,
telecast.
no, please. Now the question is that 63 lakhs pertains to the remaining 6.
No,
Tell me,
no, no.
then-
What, that, whatever bill, the estimate was 3 crore 78 lakh. We raised, did not raise bill of 3 crore 78 lakhs. We raised bill to the TV channels, NDTV, Times Now, CNN, IBN, and the bills that has been raised by that after this with telecast certificates. For that purpose, 3 crore 22 lakhs, out of which, my lord, 3 crore 22 lakhs 66,688 is the bill amount total. First
So-
20%
So out
mobilization.
of that amount, this 63 lakhs is still payable.
Yes, only out of this, my lord, all has been paid. Only remaining they are not paying is 63 lakh 9,000.
On what ground? On what ground are they not paying?
They are, my lord, taking 3 grounds, my lord, which are contrary to records, my lord. I am coming to it, my lord. वो कागज पर दिया है. Affidavit पर दिया. Wait a minute. Yes. ये तो affidavit पर दिया. Now, one ground they have taken, my lord, there is no letter of acceptance. One of the ground in their affidavit, my lord, dated 10/3/2014. There is no letter of acceptance by us. My lord, we have completed this. Everything, my lord.
Number two,
Number two, prior to making of payment, some anomalies were detected. Absolutely nothing, my lord. Every day campaign plan was, my lord, forwarded to the.
okay, number three,
Number T, out of 12 TV, 6 TV commercials were shown. That is one of the ground, man, which is contrary to record. They have handed over me only 6 for these 4 periods. And 12 is for 1 year. Their record says so.
so only 6 commercials shown.
Only 6 commercial TV shown. And whatever I have shown, my lord, for which I have raised my bills. And only 6 commercial were handed over to me for showing it for 4 months, not 12. And it is on record.
So according to them, you were supposed to show 12 commercials.
As per the agreement, my lord, 12 commercials, my lord, for a period of 1 year.
Were to be shown. But according to
Yes.
them, you have shown only 6.
I have shown to me 6 because for first 4 months campaign, 6 TV CDs were provided to me to be shown in the first phase, only 6.
So only 6 commercials were shown to
Yeah,
you.
and for which I have raised my bills.
And but they are saying that we gave you 12, we have shown only
No,
6.
no. Since 12 were never handed over. It's on record, my
No,
lord.
no, what are they saying?
Yes.
I'm not what you are saying.
No,
What
no,
are
my
they
lord,
saying?
they are saying that, my lord, which are contrary to records.
They are saying that 12 was given to you.
Yes, 12 ought to have been shown. Now, my lord, they have admitted, my lord, that 6 TV commercials were shown. They are admitted in this affidavit. Now, with regard to another ground they have taken in, my lord, which is never part of the agreement, that all these, whatever been telecasted, is to be preserved and a copy has to be submitted. It has never been part of the agreement. And even, yes, we have committed when they have asked for these copies, my lord, we said, yes, we will provide it. But the law, my lord, with regard to this is with regard to TV channel and electronic media, the Press and Registration Act of 1857 doesn't apply.
No, we are
For
not
that
going,
purpose,
we are not going into those aspects.
no, my lord, for that purpose, why it has not been given in, my lord? Because they are asking me after 9 months. Whereas as per the law of Ministry of Finance, my lord, in paragraph 5.12, how long it has to be preserved, it's been laid down. The applicant company shall keep a record of program downlink for a period of 90 days. So they ask me after, my lord, 90 days. How can I produce it, my lord? And these were the grounds. And my lord will kindly come to, my lord, at page, my lord, 27H. We acknowledge the payment been received. And that has been received after the campaign is over. Balance amount is also been paid. 1,78,70,380. We have acknowledged it. Next is, my lord, again, my lord, page 28, my representation. My lord, I come to the third last paragraph, my lord, from the bottom. We have deposited bills worth rupees 3 crore 22 lakh, so and so till date. Indian Broadcast Federation has taken up the matter with the highest authority of our organization very strongly and threatened them that stringent action will be taken against the agency if the dues are not cleared. My lord, this is nothing, my lord. Again, 29, my lord, again, my lord, representation with regard to this. At page 30, my lord, will kindly see. We have asking for only the balance amount for which we have made the telecast. Page 31, my lord, will kindly see that admitted amount. This is not other than, my lord, the under secretary to the government of Assam, my lord. In inviting a reference to the above, I like to inform the government approved payment of the balance amount of 63 lakhs. So and so group M against the telecast of TV channels, TV commercial produced by Janu Borua. So these were the bills for which we have telecasted. And bill is not of 3 crore 78 lakh, the amount involved. The amount of telecast we have made it 3 crore 22, and for that purpose we have raised the bills. And my lord will kindly come to at page 33, my lord. With regard to 4 commercial, 6 commercial, this has been cleared. Page 33, my lord. This is dated, my lord, 11 March 2013. To B. Malakar, Director of Tourism. It is further meted 19 so and so is and so and so. The government of Assam, white letter dated so and so, asks you to clear our outstanding dues on 16 so and so. We have been following up the payments on a daily basis. Our government representative is going to your office almost every day for the payment. Your department is coming up with some excuses or the other or delaying the payment. Today, what Samir Tati of your department told me and our representative is not only stunning and really innovative to defer payment, but can have a very serious consequence on our payment. That is a reason I thought I write a mail to you with a copy to all the concerned people, because it is not possible to us to tolerate so and so has informed us that you have asked Mr. Tassin to seek explanation from the previous director of your department. Why only 6 commercials were aired? This is the answer, my lord. Why 6 commercials were aired out of 12 commercials that were made? Until you get a suitable reply from your previous director, our payment will be held up. Now, this is absolutely ridiculous excuse to defer our payment. Your previous director decision to air, not to air certain commercial was nothing to do with our payment. It is internal issue which needs to be sorted out without affecting us. We have carried out the activity the way we were asked to. Now, my lord will kindly come to that page 34, my lord. A legal notice was sent, my lord, with regard to this. And for filing a civil case, my lord, that I have annexed here in, my lord. Now, statement of accounts at page 41, my lord.
So you have filed a civil suit also?
No, only a legal notice was given, my lord, as because you are an admitted fact, and admitted fact can be dealt with by this honorable court, and that's just petition, my lord. At page 41, my lord, this is with regard to statement of outstanding and interest worked on Assam tourism, my lord. These are all the statements, my lord. Money suit is never been filed, my lord, that I have annexed, nothing to suppress. Now, coming to their affidavit, my lord. Coming to their affidavit, my lord, will kindly take up that one. At paragraph 2, second paragraph, my lord, that it is most respectfully stated the government has sanctioned a sum of 3 crore 78 lakh for 12 commercials.
Affidavit
By
of?
Janu Borua.
Affidavit of?
Respondent number 4, 1, 2, and 4.
Yes. Additional affidavit?
Additional affidavit.
Yes.
We have answered this with documentary evidence. It is more respectfully stated that the government has sanctioned a sum of 3 crore 78 for telecast of 12 number of commercial produced by Janu Borua. That it may be pertinent to point out herein that though the sanction was for 12 number of TV commercial, only 6 commercials were telecasted in the TV channels. As a result of which a desired outcome of promotion tourism for the state was not received. That with utmost respect, it is stated that the petitioner requests to submit copies of video clipping commercial already telecasted by email dated so and so. However, the petitioner white so and so informed that they have not preserved the video footage. Now, this is one of the ground, my lord. I take your lordship to directly to my reply to this, my lord. That is dated 7/1/2015, my lord. and with documentary evidence.
Yes,
That is dated, my lord, 7/1/2015, affidavit in reply. And paragraph 4, my lord, I have replied to this, my lord. With regard to the statement in paragraph 4 of the affidavit in opposition, the deponent Baxu stated, as per the instruction of the Director, Tourism Department, the execution of the work has been done. Initially, only one television commercial was provided by the Assam Tourism Department to the petitioner company. Aforesaid fact is evident from email exchange between the petitioner and the Director of para 4 of my affidavit in reply.
It's a one sentence paragraph.
My lord, affidavit in reply
Yes, it's a one sentence paragraph.
is 7/1/2015, my lord. It's a big one with annexes.
9/1/15.
Yeah, 7/1, my lord. It's a big one with annexes also.
And an affidavit in reply against the additional affidavit filed by
Oh,
the.
that's a defined one, my lord. Before that, my
Affidavit filed by petitioners in reply to affidavit filed by the.
7/1/2015.
I've got 1/8/1/8.
My lord, is there annexes with it, my lord?
Yes,
Yes, that will be that one, my lord. Although I have written it as 7/1, it has been filed anyway. Paragraph 4, my lord, will kindly see.
yes.
As regard to statement made in paragraph 4 of the affidavit in opposition, the deponent Baxu stated, as per the instruction of the Director of Tourism Department, the execution of the work has been done. Initially, one television commercial was provided by the Assam Tourism Department to the petitioner company. Aforesaid fact is evident from email exchange between the petitioner and the Director of Tourism on 9/9/2011. This is before, my lord, campaign starts. On 9/11/2011, the representative of the petitioner company asks for suggestion to the Director of Tourism Department, asking whether to go on air on 10/9/2011 or to stop. The respondent number 4, the Director of Tourism on 9/9/2011 sent an email confirming that television commercial market spot number 3 has been sent to the petitioner, is to be aired as spot number 1. Further, on perusal of the email dated 9/9/2011 sent by the Director of Tourism, admitted that they will be couriering the cassette of 5 more television commercial to the petitioner so that the channel can check and log the sequence accurately. So totally 6 admitted, my lord, will come to the email directly, my lord, that has been exchanged. At page 9. Now, before telecasting, our employee, my lord, took it at page 9. It is fine, TV commercial to go on air from tomorrow. Please suggest if the same needs to be aired or stopped. Warm regard, Ruchi. Now, my lord, next page 10, my lord, again. Sir, the TV commercial sent to the attachment by you is spot number 3, but you can start with the same corresponding considering it as spot number 1. This is from Tourism Director. We are couriering cassettes of 5 more spots to you today so that the channels can check and log to the sequence accurately. So their case with regard to the 12 commercials handed by absolutely wrong. Only 6 were provided to her. Initially 1, and thereafter 5 has been couriered. And every media plans, my lord, every week, every day there is media plans. Subject to, as per the agreement, my lord. I have shown the agreement.
Okay, so
They have sanctioned it, and thereafter we have showed it.
So the basic issue is with regard to whether 6 commercials were to be telecast or
Yes.
12 commercials.
Yes.
So we have to see that only.
Yes. My lord, from this affidavit, it is clear they have provided me with 6. This email, my lord.
I don't know. Let's see.
My lord will kindly see.
We have to see the record.
And in the record also, it has been there.
Let us see the record.
Record, they are not producing it, my lord.
No, not we are producing. That is not a correct statement, my lord. Lord, if has seen 3 affidavits we have filed. But in the first affidavit, I have taken your lordship to paragraph 6, my lord, that we have said that we are disputing that. The another additional affidavit we have filed under respondent number 1, 2, and 4. They have filed an affidavit raising the question of maintainability of this case because the factual disputes are there. Nothing is admitted. Logic has seen the additional affidavit, the volume of the additional
No,
affidavit.
but what about that
But kindly-
under secretary's letter?
The under secretary's letter, Malad, that has been clarified in the affidavit. Under secretary has said in page 31,
Yes, please read.
page 31. It is, Malad, when they have requested the payments of subject is payment of balance amount against telecast or TV commercials. There is nothing that government has approved payment of balance amount of rupees. So
Yes, what do you mean there's nothing?
only to group M.
When you say government approves payment of balance amount, what is required to be said?
Malad,
And when they've
Malad,
stated the figure,
then Malad, the payment authority will not verify whether that has been work has been done or not.
Huh?
They have to verify.
then how did you approve without
that has been-
verifying?
that
Can you
has been-
verify without, can you just answer the question?
Malad.
In the same way, will you approve something without verifying?
Malad, this is
Does the government approve something without verifying?
second paragraph. Kindly see, you are requested for putting your views regarding the balance amount left with the directorate after the payment on so and so. But this has been clarified to the government. In paragraph 6, we have said.
Huh?
Malad, we have clarified to the government as after this.
With,
letter-
after the payment, you are requested for putting your view regarding the balance
Yes, yes.
amount left
Yes.
with the directorate after the payment,
Malad,
after payment of what?
All payment should be done. Yes, Malad, this is, I can't deny this, Malad. All payment should be done on receipt of specific original bills and not simply on certificates.
Correct.
All tax and statutory deductions should also be made at source, and this is there. But this has been clarified to the government in paragraph 6 of our affidavit we have shown.
Can you give a clarification on this?
But-
By way of subsequent averments made in the affidavit,
It was,
and this is so clear.
no,
I mean,
it was on, Malad, it was not a fact that after filing of this case only, this has been made known to him. In fact, the petitioner has read, Malad, that page 33, before filing of this petition, in fact, there is indication that why the amount has not been given to him. Page 33, logic has seen, Malad, the Ganesh Srinu friend has read, Malad. I'll just take a logic to Malad, that particular sentence, page 33, annexure K1. Mr. Tati there is indication that Mr. Tati has informed us that you have asked Mr. Tati to seek explanation from the previous director of your department why only 6 commercials were aired out of 12 commercials. So that is the dispute at that point of time only.
what is the cost of airing one commercial?
That,
What- no.
I'm-
There is a
Yes,
rate, my lord, government rate.
Just a minute.
I'm not ready with that calculation part.
No, you see,
Look, I have to,
no, you see, it's very simple. The government, it's not even the directorate, it's the government which has approved payment of the balance amount of 63 lakhs, so the exact figure is given.
Malad.
Now, once it has approved, it is
Malad.
implied
Malad, my,
that it is, I mean, not even implied. It is the fact that you have got to pay, that's all.
but my respectful submission.
Now-
is, as per the terms of the agreement, this is the amount and the last 10% amount is to be, that is, as per that it counts. But when the amount is to be released, the authority releasing the fund has to verify whether that work has been done completely or not.
Now, how did you, in the first place, approve payment? On
But-
what basis?
But it
Without,
is-
on just the guesswork?
no, it is 3 crore 87 lakhs.
Mr. Council, another thing, let me ask you another thing.
Logic.
This 63 lakhs that has been approved for payment, how did you come to the magic figure?
No.
I'm asking you. Forget, okay, they did not submit any bill, supposing. According to you, they have not submitted any original bill. How did you come to that magic figure of 63 lakhs, 594?
This figure, they are.
How? You plucked it out from thin air on your own?
No, not
Then
from-
how?
Not from that one.
Not see, come on, you've got to be, and then another thing, your entire case appears to be that instead of 12 commercials, he telecasted only 6.
Logic.
Correct? That is the basic case.
Yes.
Now, for telecasting one commercial, what is the cost?
That, I'll have to find out.
You have to find, not only you have to find, you see, so you cannot lay everything on his table when he has already given that your document to support his case that you owe him money. Now you are saying, no, he's not entitled to it, but you have got to tell us why. Why is he not entitled?
Malad, we have,
We-
yes, Malad, we have in detail, we have said.
You have said, correct. You have said that because he telecasted only 6 out of 12
Yes,
commercials.
yes.
My question is, one telecast of one commercial costs how much?
Calculation, I have
So
to.
please get that. Where is that in the records? Show me the record.
But-
Where does it say that?
Malad, the record, Malad, once we have placed, Malad, it was in my office, Malad, there is some confusion, Malad.
Okay,
that
forget the
they have
record.
taken back the record.
Forget the record. You go ask your client,
Malad,
what is the cost for telecasting one TV commercial?
Suppose if, Malad, one.
And supposing,
Malad,
because entire thing is not with regard to telecasting. Now, if, but your case now is that the 63 lakhs is not being given because he did not telecast 6 commercials. 12, he telecasted only 6. So you just find out what is the cost of each, we'll cut that amount.
in fact,
We just let him get,
in fact, no.
we'll cut
In
that
fact-
amount.
In fact, out of 387, they have said, according to them, they have said that 287 or something they have received. The balance 263 is to be paid to them. So the 63 will not be the cost for 6.
I do not know.
No,
I want
no,
to know your
in any
figure.
case, but the balance.
Look,
amount ultimately at the-
look, Mr. Counsel, let us not go into those issues.
Got it.
Your basic case is that because he's not entitled to this amount, because instead of 12, he telecasted only 6.
No.
Okay. What is the cost of telecast of the 6 of one TV commercial or 6 TV commercial? Just give me that figure. That's all. That's all. Nothing.
The thing is that he has not completed the entire work.
That's a different, now that's a different issue you're talking.
No, the page, para 4 of our additional.
Anyway, we'll see.
That.
Because you see, this matter is of 2013.
30.
11 years have gone by.
So,
I am ready to dispose it off. If you want, on the basis of without records, if necessary, I can dispose it of now also. Only thing is that I don't want you all to say that you were not given a fair chance.
Malad,
Both of you. So both of you. So you bring the record and you bring the answer to the query I raised today, and they will dispose it off.
Malad, the size of the additional affidavit filed by them, it suggests that there is dispute, Malad. So many records are to be verified and records are not admitted, Malad.
Maybe.
That is why.
That we
everything
will
has been
see.
got- Kindly see the
We will
size of
see,
the file.
Mr. Counsel, I do not go by the size, I go by the contents.
So, Malad,
Okay, the size may be 1,000 pages
Yes.
also, doesn't matter.
So-
So the issue is, what is the content in those 1,000 pages?
But ultimately.
It's not, you don't decide a murder case by the number of witnesses, but by the
True.
quality of the witness.
True.
So let us not go into that,
True. But out of.
because right now, you're
Out
trying to.
of- Out of 382 lakhs, 3 crore 82 lakhs, they said that 259 already we have received. The balance amount is there. This balance amount may not be for 6, but the thing
May
is
not
that,
be, may not
but-
be.
but the thing is that
So-
out of 12 telecasts, we have done 6. That is why the balance amount is not
Correct.
entitled.
So
to
please bring
is
up,
the-
so
that is
if, you see, so what is your submission now? What is your submission? Your submission is now you're going beyond that issue of 12 or 6. You've got to, you see, please bring out all your points. Don't try to add or, multiply your submission.
From the affidavit only I am submitting.
Okay.
From the additional affidavit only submitting. But kindly if.
Only
it
thing,
comes to para four,
only thing is this. As you all make submission,
Malad,
I need clarity on each point.
true, Malad.
So right now, the first point that we are stuck in is that 6 or 12 commercial.
According to us, it is 6.
According to you, 6, according to you, 12. Now, leaving that aside, the question that is posed by the court, that has not been answered. So I don't like to go to the next point,
No.
because the first point has to be answered.
How much? One cost.
Uh-huh.
One telecast.
One TV commercial.
Yeah. There
much
is a-
will it
My
cost?
lord,
I will definitely take instruction in that.
You get that,
I'll-
and then if you can bring the record,
the-
can you bring the record?
I'll-
Is it necessary?
my lord,
According to
for
you.
me, it is necessary.
But- but
Because
if the-
everything is been put in affidavit by is contrary to records. Court has asked me to check my affidavit, voluminous one. We'll see, my lord, page number in the record.
Okay,
I
okay,
mentioned.
okay.
And so far with regard
I
to
think,
that,
I think we're not going to end. I think
my
we'll
lord,
stop it now.
one thing, my lord, it will help him also. One thing, my lord, one telecast, what will be the rate? There is a rate of government, my lord, that is called DAVP rate, Director of Advertising and Visual Publicity. And on that rate only, my lord, I made national
Okay,
channel. to
Mr.
telecast.
Counselor, there's no point now
Yes,
arguing
sir.
because
Yes, sir.
I'll forget this the minute
My lord,
we leave this courtroom today.
my lord,
Because we're not disposing of this matter today. I don't think it can be disposed.
my lord.
Right, Mr. A.K. Bhuyan. No, Mr. A.K. Bhuyan appears for the petition, while Mr. D. Nath appears for the state respondents. The basic case of the petition is that the petitioner has been, is still to be given rupees 63,09,594.
Six,
594.
596.
596.
596 as per the letter dated page 31. As per the-
5th February 2013.
As per the letter dated 5/2/2013, issued by the Under Secretary to the Government of Assam Tourism Department, Dispur. The respondents, on the other hand, have taken a stand that out of the 12 TV commercials that were to be telecasted by the petitioner, he has only telecasted 6 TV commercials. First off, Mr. Dinath shall wait. He also, no, Mr. Dinath further submits that there are other issues involved. First off, Mr. Dinath shall obtain instructions as to the cost of telecast of each TV commercial.
Certainly.
Huh?
Just-
He shall also produce the records on the next day.
I'll try, my lord, because the record they have sent, but it was taken back. There is some confusion. I'll try to get.
Yes,
I'll
yes.
try to.
No, you have
And
to,
one
you
thing-
take time, but
I'll
when
just-
you bring
No,
the
I'm
record.
just indicating one thing, Lord. In the additional affidavit, we have given an NHR at NHR 1, Lord.
Yes.
We have said that reconciliation of statement in respect of the petitioner, and we have paid him excess paid by us is 27 lakhs.
All these things will
It is,
dispose it off.
it is in the affidavit, my lord, from the affidavit.
Correct. No. You bring the records. We'll see. Because his cases, your pleadings are not as per your record.
Absolutely.
So that is why I have to check.
I'll.
Only on that.
Deeply.
It can go
Well,
either
this
way.
Excess payment statement, this statement, but we have prepared and we have, the director has signed, we have placed it before your lordship. We'll just not make.
affidavit on.
List the matter on. When do you want? Give me a date, both of you. Or you want after 3 weeks. List the matter after 3 weeks. On which date? I know, first of all, on the next date, Mr. Dinath shall produce the records.
Deeply obliged, man. Deeply obliged.
No need. I don't know if they want to do it.
Obliged.
You want a date? No, you choose a date.
Date that what?
April 9th.
Nine.
9th.
Like that. Deeply obliged.
Made resolution. My lord, by this writ petition, we are assailing, my lord, basically the rates of carriage. Otherwise, my lord, we have no quarrel with anything.
Rates of carriage.
for gas cylinders.
Okay.
Yes.
Yes.
My lord will kindly come to the writ petition. While the earlier, my lord, contract was in force, the BPCL authority wrote to us. Kindly point out, since we are in the process of finalizing the next tender, please let her know what are your grievances. Now that your lordship will find at page 49. Now, this is sent by the BPCL to my lord Deepak Sangmai, that is the president of the petitioner number 1 association. Now, if your lordship would kindly come to this message was sent by mailing system. So basically, my lord, they wanted to know what are our grievances. Now the reply at my lord page number 84.
Page 84.
Yes. Ma'am. This is the detailed representation where we have pointed out, my lord, all our grievances.
This is a chart.
Yes. In fact, my lord, we furnish the details of the expenditures incurred in executing the contract. So basically, we requested the authority, please take note of these relevant factors while fixing the rate. Now, my lord, if your lordship would kindly come to page number 9, page number 58. This is a NIT, my lord, issued by Hindustan Petroleum Corporation.
58.
Yes, page 58.
NIT dated?
It's dated, my lord, 31st of May 23.
Yes.
Kindly see, my lord, on the left-hand side, line description, 100 to 340, so and so. Price band 1534 to 1687.
Meaning to say that, what does it mean?
This is a higher price, my lord, than what has been fixed by BPCL for the same period.
So is it's good for you?
No. We won this price. They are not giving us, my lord. That is our grievance.
No. So this NIT
No,
has been published.
This NIT is not by the BPCL, my lord. This NIT is by Hindustan Petroleum Corporation. We have brought on record to show for the same period, BPCL has fixed a higher rate. HPCL.
So this is by HP.
HPCL. Now, my lord will kindly come to the improved NIT. That is
No, just a minute. This price band of 1534 and 1667
yes.
means that the bids will have to be within this.
Yes, within this or plus minus 5%, that is a normal procedure. Right? Now, my lord will kindly come to the improved NIT at page number 117.
Achha, this page 58 is 1534-1667 or 1687?
One second. It's 1687. 1534 to 1687. Now, my lord will kindly come to page 117. This is the fresh NIT and the relevant portion is at 1821.
NIT by
Now, by the BPCL.
dated? 31st. 31st.
31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st. 31st.
This is dated, my lord. 4/8/23. Now, on top, lordship will kindly see transport tender for BPCL, Numoligarh Refinery Marketing Terminal. Bidder to quote rate in percentage, that is -5% or plus to 5%. Now, please come to that.
Just a minute, where did you
I'm
say?
reading on top, my lord,
Page
121.
121. Bidder to quote rate in percent ban 5%.
Yes. Bidders to quote rate in percentage band from -5%, minimum below so and so, to +5%.
What does BMR mean?
Benchmark rate.
Benchmark rate, yes. Now, my lord will kindly come to the rates in respect of the truck, which has a capacity of carrying 342 cylinders. Now, kindly see, my lord, the rate for 342 524 number 14.2 kilo cylinders capacity truck for BPCL Numoligarh Marketing Terminal. Now, category 342 capacity plane, that is intrastate, my lord. Kindly see, from 0 to 100 kilometer rate is 15 rupees 87. That means for 1 kilometer of carriage, my lord, will get, sorry, minimum rate fixed is 15 rupees 87 paisa.
For 1 kilometer.
1 kilo. Then from, my lord, 101 to 300, minimum price, estimated price is 15.69. Then 301 to 500, 14.03. 500 to 600 is 13.59. And from up to 600 kilometer and above, it is 12.79.
So it goes lower and lower, the rate goes lower.
Yes. No, my lord, our only case is, my lord, in the earlier contract, which was settled in 2017.
Earlier contract.
Earlier contract was settled in 2017 for a period of 5 years, my lord.
Yes.
Then, my lord, the diesel price was somewhere around 58 rupees. Now, diesel price is 80 plus.
Nearly 100.
That is, my lord, the basic, our case. Now, my lord, I have, if a lordship should kindly come to the affidavit in reply, I have given an chart which indicates the position as was obtaining in 2017 and, my lord, on the date of coming into force of the new tender. If a lordship should kindly have page 431. Page 431, para 5.
Yes.
Please see, my lord, instead of 342, now it is 360 cylinder capacity. Now, kindly see, my lord.
Just a minute.
Yes.
431.
360 category truck.
360 means, my lord, earlier it was there, now it is 360 cylinder.
Yes.
My lord, I must also indicate one thing. My lord, for the first 2 years, the rates remain static. Thereafter, there is slight increase. It is there. So please come to the chart now. Say, for example, 0 to 100 kilometer, my lord. The rate, when, my lord, the earlier tender was made, it was 13.17. Now, by application of that formula, when this present writ petition was filed, my lord, the rate we were getting was 15.29. And now, as per the new tender, my lord, I'll have to submit my rate at, if it is minus 5%, then my lord, 15 rupees 07. That is our case. My lord, therefore, what I was submitting for a lordship's kind consideration is, there is a stay order operating. Let this stay order operate for 15 more days. Let them consider this aspect. I'm not asking for anything else. Or lordships can delegate us to the, my lord, mediation of the Guwahati High Court. Let authority and the petitioners sit for 2 weeks time, my lord. Then, my lord, they will come back to you, lordship take a call. My case, nothing. And one averment in my writ petition, my lord. If your lordship would kindly come to para 18, my lord. I'll just show
Of page.
of the writ petition, my lord. Page 18. Sorry, page 21, para 21. Page 21, para 21. That the petitioners beg to state that at the time of floating of the earlier tender in the year 2017, price of the high-speed diesel per liter was 57 rupees 66 paisa. At present, the rate of HSD per liter is 89.65 and difference of price in per liter is 31.9. So, my lord, kindly see in 17 and now there is a difference of 32 rupees. Now it is still more, my lord. So they should take note of all these things while fixing the rate. Now it's purely a technical matter, my lord. Therefore, I am not troubling the lordship. If both parties sit before the mediation center, and if they can come to some conclusion, is well, otherwise lordship takes a call after 15 days. Or lordship may relegate the matter to the authority, let authority decide.
Depending upon what they have to say, if they are agreeable to it.
Of course, my lord, it depends upon what they say. But prima facie, my lord, it looks like our grievance is justified. But I am also conscious of the fact that this court is not the competent authority to go in. That's why I was suggesting, my lord, either mediation cell or the authority themselves. My lord, I can show, I've prepared a chart, my lord. I'll just give a. So many factors have been taken note of, my lord. Diesel prices have gone up. The expenses for, maintenance has gone up. But kindly see, my lord, expenses of truck with 360 capacity per trip for all so and so categories.
What is this RTKM?
Return trip kilometer. That means, my lord, I'll go also and come back also. And while coming, my lord, the vehicle comes empty. That is also a grievance.
Not always. Not always.
Maybe.
They carry.
Not necessarily. Sometimes maybe. But
They
it depends, my
little
lord.
bit, yes.
It depends. Anyway, there was an agreement that they will address that. That also.
But then there's another.
No, I'm not even taking note of that, my lord. Kindly see, my lord, for example, 0 to 100 kilometer. Now, end of the day, we are losing 5,448 going by today's calculation. We make profit only in 300 to 500, 500 to 600, and 600 and more. Other two, my lord, we incur loss. Normally, trips are very nearby, my lord. On top of this, these all are the other expenses. So, my lord, we do business to make little bit of money. Therefore, my lord, they should consider.
But the lesser prices will be better for the consumers.
Of course. Of course, and for the organization also.
The general public.
No, provided there.
You and me at least are cooking.
No, my lord, what I'm saying is, so, at the end of the day, my lord, it's not that these people have become very rich by doing this. They are somehow living, my lord. Logic knows nowadays how difficult things are.
I don't know.
I'm just, I mean, I don't. wish to-
These carry contractors are very rich in fact.
Absolutely.
Yes,
They are controlling, they've got a big controlling stake,
No, my, it all
not
depends-
only in LPG,
in-
rice.
No, it all depends on what they carry, my lord. One who carries private things, yes, they are good. But these are, my lord, all, these are regulated business, my lord.
No,
Huh?
in fact, these carry contractors.
And my lord, no, my lord,
Yes.
here we are the consumers are of the Bharat gas. Here is very, had it been Indian oil, things would have been different. Their consumers are very, very less, my. BPCL, very, very less.
But nevertheless, still consumers.
Number is less. Therefore, when they multiply, the amount is less. So these are the expensive. Now, my lord, what had happened, if your lordship could kindly come to. That's why I reply to continue. My lord, I have referred to page number, my lord, 49 once,
Yes.
whereby they
Wanted to know your grievances.
requested us what all, then my lord will kindly see.
Page 49.
Ah,
Yes.
then we replied, my lord, please come to page 50.
Yeah, what about page 84? That
No,
is
my-
not your reply.
No, that's separate one. I think it's 50.
Oh.
Ah. These are the grievances. Let them consider these at least, my lord, because they themselves solicited them. Kindly see, my lord, the BPCL accumulates the rate for carrying LPG cylinders from various aspects, such as distance of road from NRL to distributors, and the rate is fixed for per cylinder per return trip basis, but there is no separate rate for hill areas. Everybody is aware of the fact in the hilly areas, fuel consumption is higher than the plain areas. Moreover, more experience is required to ply a vehicle in hill areas. So reasonably, there should be separate rate for carrying in hilly areas. As per, but this is how, my lord, we have, I mean, ventilated our grievance. Let them at least consider this reference, they themselves solicited. That's our only prayer, my lord. I'm not saying to interfere with the contract or something. They have not finalized as yet. Before doing it, they will consider it.
Mr. Saikia, so his only prayer.
His prayer is very innocuous, but it is not as simple as that.
Okay.
The tender, the earlier round of tender contract period was over on 31st of July 2022. And they are running on extension. Everybody is running on extension. It was initially extended up to 31st of December. Now there is an order that it will be
31st May. NIT was 31st
July.
May.
Oh, sorry. 31st May? No, 31st July.
July.
31/7/2023.
Just a minute, page 58.
Because of this litigation, we could not go ahead with the tender process of
31 July, yeah?
Yes.
July.
And they participated in the pre-bid meeting. They have raised its grievances and these were all outrightly rejected. So there is no scope of any mediation.
Raised in a pre-bid meeting, you mean prior to the NIT being issued or after the NIT was issued?
After the NIT.
Naturally, after NIT.
After NIT.
After NIT and before also.
After submission of your bids, no, before.
So they did not submit bid at the first instance, Lordship. But subsequently, there is an interim order that they can participate. Few of them have participated.
Okay.
Last date was 18th of August for submission of the bids. And the tender was issued on 4th of August.
23.
23. 4/8/2023 was the bid issuance and 18 was the.
No. NIT was 31/7.
No, the earlier one. They were relying on the earlier one. They are comparing everything with the 2017's NIT. So that contract period was over on 31st of July.
Okay, that was 31. Okay, that was over on 31/7.
Lordship.
What was the new NIT dated?
New
4/8.
4/8.
4/8/23.
Last date was 18/8. And there is an interim order now in force, which says that we can go ahead with the technical bid process, but we cannot open the financial bids.
Okay, so all the grievances were considered
Yes.
and rejected.
And Lordship,
Or rejected when? Why letter dated? Is it here?
Lordship, I'll place it, Lordship. Maybe at 1 o'clock now, Lordship, would like to rise.
Okay, I think it takes some time.
Yes.
Not much time, I think.
No, not much. No, we'll place the case because the case is
Case
very,
law. Basically, you want it to be disposed of.
absolutely, that's why I'm here, Lordship. The oil authority, the respondents have not considered the price of HSD from what their pleadings, and their submission is only HSD. But they have also said about the toll gate prices, no provisions for loading, unloading. Then the entire operational cost factors are not considered. And various costs, including which are very relevant, are not considered. This is their stand. 5 grounds they have taken.
No, one is, no,
One is
but
it-
he's
One
confining
is the
himself.
price of the
No,
HSD.
I'm not confining.
Okay,
but as
okay,
an
all that.
illustration, I say.
Okay, HSD.
Let me just indicate one small thing, madam. Under the earlier tender, as far as toll gate is concerned, if we can submit any authentic, voucher, then they used to reimburse us. But this time there is no provision,
Okay, so,
amongst others.
so toll gate and then loading, unloading,
Loading, unloading, then toll gate charges,
toll gate charges.
then operation cost. Not
Operation.
factors are not included. And also various other costs which are not included. This is their stand in their
Mi-
agreement.
so
I am
mi-
taking the words
miscellaneous.
from their petition,
Miscellaneous cost.
miscellaneous cost.
Okay.
And one more important ground is that new rates are less than the earlier rates. That means BMR of 2017 was more and BMR of 2023 is less,
New rates are less than.
lesser than the earlier rates. And they are basically challenging the whole tender process or the tender notice or otherwise clause 14, that BMR.
Okay, class 14 is BMR.
Yeah, BMR. So my reply will be specific, Lordship, point by point. My first ground of submission would be, Lordship, that this is an association which has lost the petition. There is no such resolution of the association. So technically, this petition is not maintainable, which they cannot deny. One authority letter by one person is not the resolution of the association.
No resolution to file the writ petition.
Exactly, Lordship. So, section 6 under the Societies Registration Act 1860, suits by and against society, that provision of law is violated here. And there are cases of the Supreme Court as well as of this Honorable Court. So that is on technical ground. Number 2, Lordship, the tender was issued on 4th of August. Last date of submission was 18th of August. And in the meantime, they came before this Honorable Court and there is a stay order that we can proceed with the assessment of the technical bids, but we cannot open the financial bids. How many have participated? 13 of the previous tender of 2017 have participated and 20 new entrants are there. 20 in total, 33. I'm not sure who are the members of this association. Till now, they have not disclosed that. So whether from those 13, because they say we are part of the 2017, how many of them? What is the total number of their association members? All these factors, all these figures are not here. So there is a large scale participation. 33 participants are there. And I think 30 are technically qualified out of 33. So at least 20 new entrants are there who have no objection regarding that clauses. Without going into anything. If I saw one line before this Honorable Court, why they have filed this, their whole intention will be clear. Their reply, paragraph 21. Because earlier,
the number of cylinders carrying capacity of the trucks were lesser. Now it is more because of a central government's notification of 2018, where the load capacity of the trucks are increased.
Bigger engines.
Axle power has been increased, therefore more cylinders can be carried in a one truck.
Bigger engines and.
Bigger trucks.
Bigger trucks.
Bigger trucks. That notification also I'd like to place. So the motive we have to know, Lordship. Why this writ petition? Why, when there are 33 other participants, willing participants? So that notification we have mentioned in our affidavit and we are placing it, Lordship. Which allow the companies to engage bigger trucks to carry more cylinders in a single trip. Revision of safe axle weights for transport vehicles and enforcement thereof. The permissible safe axle weights of good carriers are last modified in the year 1983. Over the years, significant improvements have taken place in the tire technology, vehicle designs, pavement designs, etc. The global axle weights norms are higher as compared to the existing Indian norms. The lower axle rate weight has been often cited as one of the major factors responsible for high logistic costs in India and incidents of overloading. The issue of revision of axle weight was also raised in the meeting of the group of transport ministers of the states who recommended to increase the permissible axle weight of transport. So the overall impact of this that we can have bigger trucks to carry more cylinders in one trip. Now, in their reply, why they are aggrieved now? In fact, there is an increase of 11.7% of the BMI. Earlier, I'll explain it.
BM
That
benchmark.
benchmark. There's a 11.7% increase. It is not decreasing. And they have the liberty to quote 5% above the BMR. They can quote either 5% less. The leeway is given 5% plus or 5% minus. So if they are not happy with the BMR, they let them quote 5% plus. So 10% handle is there. So if it is 100 rupees, then I can quote 105 or 195 also in between that. So paragraph 21 of their reply.
Yes, which page? Running page?
Running page 438. So I'll come to paragraph 14C, but let me have a reading of this small paragraph. With regard to the statements made in paragraph 14C of the affidavit in opposition, the petitioners beg to state that the example cited by the respondent is without any reasonable justification. Stopping here. At present, most of the members of the petitioner society have trucks with the capacity of 306 or 450 number of cylinders. In response to the impugned e-tender notice dated 4/8/2023, the members of the petitioners #1 society are now required to modify their trucks from 306 to 360 and 450 to 560. So now there are more cylinders capacity we are asking. What is our figure? Our present figure is, Lordship, it has gone from 450 to 524 and 306 to 342. Two categories we have. So earlier, whoever was carrying 306, now it has been, they can carry up to 342. And from 450, it has been increased up to 524. So there is an increase of 74 cylinders in the bigger trucks.
Where is that increase?
That I'll give in the affidavit, I have all the figures. Just to have a initial opening remarks on this also. So this is actually creating problem for them. They have older trucks. That is the issue. So for that, the whole system should suffer because I do not have an upgraded vehicle. And I am giving a wrong impression to the Honorable Court that BMI rate has come down. We have considered every factor, every guideline. This is a public sector It is not a private company, Lordship. So I would like to take this honorable court to my affidavit in opposition. Few paragraphs I would like to place, which will clarify everything. These are very technical and factual. That is why I would like to read 2-3 paragraphs from this affidavit. Lordship may take my affidavit. It starts at page 120.
So they cannot carry the higher load. They have to go by the old load.
Load.
They'll have to, the older truck,
Older trucks,
we'll have to
up
go
to a
by,
certain level, they can do, but they cannot have the full capacity.
they cannot have the full capacity. They'll
capacity.
have to go as per the
That
old
is
load.
where their cost of operation will be more. Why should the public suffer for that? Ultimately, the overall intention of, as Lordship has already said, the public interest, ultimately the burden will be shifted to the consumers. Not the company will take that burden. It's a welfare society, Lordship. It's a commercial transaction. So we should be most economical and prudent. So if Lordship is pleased to take my affidavit. So paragraph 3, I have said.
Page
128. So paragraph 3, I have raised the issue of technicalities, Lordship, that they are not, this association is not properly presenting their case without having the resolution, the technical ground. Paragraph 4, I have given the rates they have shown are incorrect, Lordship, and we have given the correct position. Earlier times, Lordship, paragraph 5, may I read it, Lordship? The deponent corporation made the reimbursement of the payment of toll tax to the contracted transporters on monthly basis in view of clause 27 of the tender 2017. Paragraph 5, page 131.
Yes.
So paragraph 5, earlier, yes, Lordship, whoever submits the toll documents, the receipts, it was reimbursed. Now what we have done in the new condition, Lordship, it is undisputed that existing toll rates are inclusive of the price. If there is any enhancement of the taxes, toll tax, then additional amount can be reimbursed. And if there is new introduction of toll tax in some new routes, that will also be reimbursed. I don't think they will disagree with it. This is the condition laid down in the.
So
Existing tolls are inclusive in the price. BMR. Existing. If it is 10 rupees on a route, 10 rupees is inclusive. If it is enhanced at a later stage to 15 rupees, that 5 rupees they will get. And tomorrow, suppose there is a new route or new toll gate comes up between Guwahati and Numaligarh. That will be given to them because that is not in existence today. So existing rates are inclusive. Those who are in future, that is not included. Regarding the return trip kilometers, Lordship, it is a flexible one. In the earlier times of 5 years, there were 116 number of changes.
what do you mean? What do you mean?
Routes. Suppose from Guwahati to Numaligarh. There are 2-3 routes.
Okay.
So return trip kilometers at one route is already fixed. Suppose there is a change in the route or new shortcut has come up. So that will be modified. So time to time, whenever it comes. So those flexibilities inbuilt. So nobody has to worry about that. So we are also having our eyes open. They are also can raise all these issues. So in the previous 5 years,
rates will be changed.
Rates will be changed. In fact, petroleum rates every month it is changed. Every month, so flexible. So here in paragraph 6, we have stated that in the previous 5 years, page 132, a total number of 106 number of RKM has been changed in the northeastern region. Suppose there is a landslide in Mizoram. So different route is being used, or to Garo Hills, Lordship. There are 2-3 routes. So these flexibilities are inbuilt. We cannot say that these are arbitrary. For example, paragraph 7, we have cited one example. With regard to the statements made in paragraph 5 of the deponent begs to that after receipt, paragraph 7,
Yes.
of the letter dated 7/12/2020 from the petitioner society, the transporters were advised to take the route Telegram via NRL main parking, Pura Bangla NRMT. It is stated that though after verification, the deponent corporation increased the distance by 18 kilometers instead of 14 kilometers, as claimed by the petitioner society. But in utter surprise, they were using the old route, Telegram NRB till March 2023. So we have increased also, but they used to operate by the old route also, which was found out in March 2023. The tender was up to 31st of July. Then earlier, there was no distinction between plain areas and hill areas. There was request from them during a meeting held in the month of January. We sought suggestions and it was given by them also. So this time, Lordship, there are two categories. So after the negotiation and after all these factors were raised, so we have included that there will be a big higher rate for the hill areas because page 112. It starts from page 111 of the writ petition. If the last line from page 111. So all the transporters were informed by the authorities. BPCL tendering procurement department has already started working on phase Numoligarh tender for Northeast. So this was issued on 31st of July. August 4th, the tender was floated. And there was certain discussions prior to that. The inputs as per current market condition, page 112, project. The inputs as per current market conditions representations are already available with the BPCL's tendering / procurement department. Our CPO Bombay office is planning to float the tender early in August 2023 as per inputs taken from you. Point was reply to our points. In the meeting in March 2023 between BCPL and transporters, it was confirmed that hill rates will be considered in the new tender. So we have introduced that. As for the tender condition, toll charges are reimbursed to all the transporters who provide the toll revision notifications and put up claims for the same. For other expenses as per tender condition, diesel rates adjustment is provided on a monthly basis. So their whole apprehension goes here. Their main thrust is the diesel price we are not considering. They are giving the example of the price of 2017 and the present price of high-speed diesel per liter. So we don't have to wait for 5 years for revision. Every month there is a revision. And after that also, 4th and 5th year, there is a revision of the prices of this 5 years period. Next, other than diesel, 4% escalation is provided on commencement of the 4th and 5th year tender. Same are provided in the pricing of the August 2021 and August 2020. This is regarding the previous, but this time also the same. The 4th year and 5th year, there will be a revision. Paragraph serial number 9. The return trip kilometers is fixed based on the actual distance traveled via appropriate route. In cases there are changes due to new roads, bypasses, entry restrictions by civic administration, etc., same needs to be notified to the corporation by the transporters with notification. Alteration of RTKM are immediately processed accordingly. quite liberal, Lordship. This is not dogmatic agency. So all these things, they have to inform, and these are, all these provisions are there within the tender of. Regarding one thing, Lordship, that they are comparing the BPCL's tender with the HPCL's competitor. 17, we have stated, each corporation is a different business entity and have different methods to arrive at the band to be offered by the transporter of LPG. So every company has their own policies, own parameters, and I'll place a Karnataka High Court judgment on this point. The brand value also is very important.
Land value.
Brand value. Many people do not go to a particular X petrol pump. They go to a Y petrol pump. Why? Because of the brand value. So in paragraph 9, we have stated, page 133. Paragraph 9, subpara A, page 133, Lordship. That during the tender of 2017,
Yes.
that during the tender of 2017, there were only 5 distributors in hilly areas against 21 distributors. At that relevant point of time, the concept of hilly RKTM was not discussed by transporters or by any other person. And BPCL, whose presence was very less in Northeast in 2017, were not aware of the said requirement. Now, on request of transporters, BPCL has introduced the hilly RTKM in the tender dated 4/8/2022 for
RTKM is?
return trip kilometers to and fro. In the tender dated 4/8/2023 for supplying to distributors in hilly terrains. Then toll tax, regarding the toll tax, Lordship. Toll tax reimbursement is being done on monthly basis based on the receipts submitted along with the claim. The amount mentioned in the receipts are considered for calculating the total amount for the month. For non-fuel components, NFC 4% escalation is done in the 4th and 5th year of operation as per tender guideline. As such, NFC escalations was provided in the pricing of August 2021 and August 2020. This is regarding 2017, and same provision is also there in the present one. RKTM is based on actual distance measured physically wherever possible or via any technical measures like Google Map, vehicle tracking systems, etc. Then F. The previous tender work order was issued to transporters for the period 1/8/2018 to 31/7/2023 for a period of 5 years. For the non-fuel components, NFC 4% escalation is done in the 4th and 5th year of operation as per the tender guideline. As such, NFC escalation was provided in August 21 and August 22. As for the tender of 2017, the transporters were liable to pay loading, unloading charges at both plant and at distributors end. The transporters were liable to pay the loading, unloading charges from the beginning of the contract. However, they were not paying till July 2023. Now coming to paragraph 10. There are 3 paragraphs relating to BMR calculation. Paragraph 10 and 2 more paragraphs. I'll place it, Lordship. Paragraph 10.
Just one thing.
Lordship.
Are we supposed to go into these issues?
At least they are saying that we are arbitrarily doing it. So I will at least try to give a cursory look how we do it. I'll not go into the nitty-gritty details.
No, because these are basically
highly technical.
experts, right?
Highly technical.
Nothing for
That
us
is
to-
why
Huh.
this is not the appropriate forum also.
Yeah.
But at least I can show before this honorable court that there is the BMR of 2023 is not less than of 2017, number one. And what are the factors we consider? What are the basic parameters, general view for layman also?
No, you showed me that, I think, that percentage.
Yes, I'll go, paragraph 4, paragraph 20. These are very short. I'm skipping 10 then.
Yes, because I think,
Yes, then regarding loading, unloading, lordship, that is at paragraph 11, I have said. Now, new route is paragraph 13. 14 and 20, let me place it, lordship. It will clarify everything.
para 13 is,
Paragraph 13 is regarding the new routes, RKTM,
just a minute, just a minute.
RTKM.
Para 11 is regarding,
Paragraph 11 is lordship regarding the clause 9, loading, unloading charges.
loading and unloading.
Earlier, they were saying that we are giving them loading, unloading. In fact, that was not correct. We never gave them loading, unloading charges. This is inclusive of the rates. That is an incorrect statement they have made before this honorable court.
Para 13 is
Para 13 is regarding the return trip kilometer,
RTKM.
RTKM.
Then
Paragraph
14.
14, let me read it, lordship. All the clarifications are here. The statements made in paragraph 19 of it is not wholly correct. The deponent denies the statements of the petitioner that distance-wise BMR has been fixed at a rate which is lesser than the rate that the deponent corporation had paid to the transporter in the terms of the earlier NIT. The deponent state as follows. BPCL floated tender for packed LPG transportation for the period of 5 years. LPG bottling plant twice. Internal estimates are prepared consisting of various elements for arriving at BMR rates. Inputs from various sources like vendors, equipments, manufacturers, bottling plants, transporters who are transporting packed LPG cylinders from these plants, statutory bodies, etc. are taking to arrive at BMR rates. BMR rates are arrived at through a 360-degree approach by considering inputs, requirement, and market conditions in prevailing scenario. Most of the parameters vary from location to location, state to state. In the tender, the transporters are given the price bands, namely upper band 5% plus the BMR or the lower band 5% below the BMR. And they were given the options to put their rates within the price bands as per their free will. As the scope of business is published in the tender, only those transporters who find the rates feasible to them participate in the tender. In the new tender, rates are only for 342 cylinder, that is range 306 to 360 cylinders capacity, and 524 cylinders, range 450 to 524 cylinders capacity, as per the increased carrying capacity in view of the Ministry of Road Transport and Highways notification 16/7/2018, which I have placed, lordship. Situated thus, the capacity of trucks has increased by 36 cylinders from 306 to 342 in a smaller truck, and from 450 cylinders to 524 cylinders by 74 cylinders. Therefore, the overall cost of transportation would increase for the same trip, and accordingly, revenue per trip would automatically increase for the transporter. As regard rates in free delivery zone, up to 100 kilometers, it is rupees per cylinder. Afterward, it is paisa per cylinder per kilometer travel. For example, if the distributor is at 150 kilometers and the rate is 14 rupees per cylinder per kilometer and 342 cylinders are sent, then the freight is calculated. It comes to 7,182. While in case of 360 capacity, freight will be 6,426 for the same trip. As such, in that event, the transporter would get revenue of 756 more, which is more than 11.7%.
No, please explain this part. The distributor, if it's this 342 cylinders,
Yes,
the rate is 7,182.
yes,
And if it is, it's 7,182 for all 342,
all 340.
all 342. So if per cylinder, it comes to how much?
It will come to in between that figure. Just I'm giving that because our rate is also given there. It will. It is 363.
Rupees 14.
363. It will be in between this lordship. The chart is given there. In 342 capacity truck,
Into 14%.
it is 15 rupees 87 paisa, 342 capacity planes, and in hill areas where the hill area directly it is not there, there is 19 rupees 30. There is another calculation in the chart. So it is within that band.
No, no.
Yes. So that kilometer is very important here. What the distance?
No, this 7182 divided by 342, it comes to how much?
Yes. The calculation is precisely this is why I did not want to enter this part. Huh? Even high? Even high, sorry.
21.
91.
2.92. 22.92.
22.92.
21.
No. 7182 divided by 342.
Yes, 21.
21. And how much does 3426 divided by 306 come to?
1.
426.
26 divided by
306.
306.
306.
21.
The same rate.
No, it cannot be lordship.
Yes. Twenty-one.
6426
Divided
divided
by
by
306.
306 and 7182 divided by 342.
Yes, 2120.
It is at the rate of 14 rupees. Calculation is done on the basis of 14 rupees, lordship.
No. What I am saying is, when you divide the total rate by each cylinder, then what is the cost at the destination point?
Here, lordship would see two figures are common. 14 rupees per 100 into 342 into 150 kilometers. And earlier what they were doing, it was instead of 342, it is 306.
Correct.
So that is why this difference is there. Both her other parameters are same.
Correct.
Only difference is instead of 306 earlier, now it is 342 in one trip. So definitely it has to be more than the below one. So number of cylinder in the first category is more. 36 cylinders are more in one trip.
Yes.
And that way they are getting 7,182. This time that instance. So 14 rupees into 100 kilometers. 14. 342 cylinders in the first trip. The middle part is 342 and the middle part is 306. That number of cylinders. Into 150 kilometers, both the distance is same. 14 by 100 to
Pesa per cylinder. Pesa per cylinder. Pesa per cylinder. Pesa.
No, I get it. Now you see, so it's like this. It is 21 rupees. But the thing is that
More cylinders.
more cylinders
More
are coming
cylinders in one trip.
in one trip.
One trip.
So you have got another, so it comes out cheaper.
Much cheaper.
From their perspective.
Yes. It comes out cheaper.
Because logistics, the trip counts.
Because the rate is the same, whether it is this way or that way. But then because that new trucks are carrying more load. So it comes out cheaper.
Cheaper.
It comes out more. But then no, I want to see with the earlier rate.
Earlier, yes, now for the same trip, the driver cost is same, other ancillary costs are same. Maybe little bit more in the HSD price. So all these factors are considered. Therefore, paragraph 20, the explanation is there. Now let us go to paragraph 20, Lords. Now, what are the considerations we do, Lordship? Paragraph 20, 141. And paragraph 16 also, there is an increase. Anyway, Lordship, let us come to paragraph 20.
Yes.
The deponent states that all the inputs provided by the petitioners were considered while arriving at the BMR. Also, the bidders have been given options to quote above 5% of the BMR. It is pertinent to mention here that the benchmark rates as specified in clause 14 of the tender notifications are based on departmental guidelines and also considering the different parameters and criteria. The deponent stated parameters of benchmark rates as specified in subject tender of 2023 for road transfer are backed LPG are as unders. BMR rates are finalized based on the various cost elements of vehicle cost, operation and maintenance cost, capacity and running optimization model. The various costs can be categorized in three categories. One is financial cost, second is fuel cost, third is operating cost. The finance cost includes the capital cost. As per Government of India Vehicle Scrapping Policy 2021, the commercial vehicles that are older than 15 years will be deregistered from 1st April 2023 onwards. The life of the vehicle is considered as 15 years as per the guideline. Vehicles are categorized in three age categories, 0 to 5, 5 to 10, and 10 to 15. Next, interest rate is considered in the line of current SBI lending rates on the assumed loan component. Then depreciation. Depreciation is computed considering 8 years useful life and 5% salvage value as per Companies Act. Income tax savings on interest and depreciation is computed considering tax rates at the rate of 31.2%. This is in line of the provisions of income tax slabs. Next is fuel cost, diesel cost. The cost of diesel available in Numalik or Assam on a particular date is being prepared is considered for calculating the fuel cost. The diesel rate is published in the tender and based on any increase or decrease in diesel rates, escalation and de-escalation is provided to the bidder on monthly basis. Consumption of diesel is considered based on the capacity of the trucks. For 342 capacity, 3.8 kilometers per liter, and for 524, 3.25 kilometers per liter. So the bigger capacity has a more consumption of diesel. Then operating costs, salaries of the driver and helper, lubricants, AdLub and grease cost, insurance charges, VTS charges, that is vehicle tracking system charges, statutory charges like road tax, RTO fitness charges, permit and calibration charges, painting cost, battery cost, tire cost, maintenance cost, miscellaneous expenses like office expenses and seafood. Miscellaneous cost. Then 11, all existing toll tax pays 146 Lordship. 11, all existing toll taxes have been considered tripwise for each LPG distributor customer. Any increment in existing toll charges or introduction of new toll charges en route to any LPG distributorship, consumers will be additionally reimbursed on submission of bills. And finally, we have also considered transporters' profit margin is considered, which varying depending upon market conditions. Then optimization of revenue, the optimum number of trucks required capacity-wise is arrived at through various parameters like sale volumes of each LPG distributorship, customer location, return round trip kilometers for each LPG distributorship transfer consumer locations, LPG go down storage, peso license for each LPG distributor's customers location, any constraint on the maximum capacity of trucks which can serve any LPG distributor customer location, loading or unloading, transit times of the deliveries, optimum LPG cylinders, type combination size of the delivery load, loading and unloading charges at LPG distributors in average speed of vehicles on different sectors like hilly, plain, cities, highways, etc. Then existing transportation rates, market condition and industry. The existing rates applicable to the concerned location, overall market condition and industry rates in the concerned locations are considered. Based on the above, various slabs BMR rates are arrived at, which provides flexibility to the bidder to quote 5 plus minus 5%. Yeah. The retail selling price, other cost inputs of diesel has the freight component inbuilt in it, and hence any increase in the freight will lead to an increase in the RSP, retail selling price, diesel. Hence, it is important to have reasonable freight rates for transportation to avoid burden on the general public at large. This is the public interest component, Lordship. Then next is higher rates are given for hilly terrain strip due to various factors.
Before that, one thing, so if someone of you had taken me to a chart
Ah.
with regard to the old rate
Yes,
and the
in
new
our,
rate.
in our reply.
Yes, I just wanted to see that.
Yes, page 431.
Okay. Well, which one? Para?
My lord, para 5.
But this is not with regard to the old
Both.
rate.
Not of 2017. They have compared it with 2021 and 22.
No, escalation.
The
So, my lord,
escalation marks.
First column, while in second column, rates on 1/8/2018. That is as per 17, 13 rupees 17 paisa per kilometer. Of course, it was 360 cylinder. Then, my lord, rate per cylinder at the date of filing of the writ petition, that is in 2023. It was 15 rupees 29, and now it is 15 rupees 07. In a 360 category, my lord. Then for 450 category, we have made a separate calculation.
This is for the 2017.
Yes, second column is 2017 rate.
So now the rate is lesser.
Yes.
So good for the consumer.
But help for us.
Maybe, but the general, the maximum benefit that can be given.
As a PSU, my lord, they are not, I mean, they have to look for the welfare of the people also. Yes, of course, it's a business entity. They must live in a business environment. That also we agree, my lord. At the same time, my lord, some compassion for this. Now we'll have to change our tracks, my lord. That is a heavy cost.
That is the ultimate actual.
That is the problem.
No, this is India, my lord. These are the problems of Indian people.
No, but at the end of the day, you see the general public has to be the final beneficiary.
Yes, but my lord, if a provision is made for these people, end of the day, general people will be benefited, my lord. General people include these people also. Not that, my lord, they are living on hand to mouth.
Yes.
Now, Lordship has in the initial, they are not hand to mouth people. At the very beginning, Lordship said. Now the thing is that we have to change with the time. At one point of time, the normal telephone was there. Now, lot of changes, and now the models are changing every year. So we will have to upgrade. We have to, and it will sustain in business.
So the basic thing the petitioner is saying is that since the rates have come down, they're going to
Plus, we
lose
have
out.
to change the track.
And plus they're going to change the
We have to continue.
It has not come down, Lordship. In my humble submission, it is an incorrect submission.
No, come down meaning, yes, the transportation rate has come down according to their calculation.
Yes.
So what was
Transportation cost,
rate?
if we have to look at the per trip, it is more. Per trip, it is more. 11.7% more.
Per trip, it might be more, but per cylinder, it will become less.
Less.
That also I do not agree, Lordship.
No, anyway, even if it becomes less, what is the problem? It is
in
for the
pub-
public.
It is
It's
in
for the
pub-
public.
yes,
My lord, can I just 1 minute, my lord?
Yeah.
My lord, my learned friend, when he began his argument, he said in the pre-bid meeting, all these things were told.
Sardar.
This is not correct, my lord. In pre-bid meeting, all that we are told was how to submit the tender. And secondly, my lord, my learned friend was supposed to show that letter or something by which, my lord.
I
Our
have
grievances
not
were made.
completed my submission.
No, I'm not saying, I'm
Ye-
just pointing out. No, you can argue, I'm not interrupting you. All that I'm saying is, my lord, that's why, my lord, at the very beginning, I made this submission. I do not like to trouble your lordship with all these intricacies. Only thing is, my
Anyway,
lord, let them consider, that's all. I'm
This,
not saying
this,
anything more.
anyway,
Ah.
now, so basically right now you want an
Either-
answer
Ah,
to whether your queries or whatever inputs you had
no,
given
they themselves
have been
asked,
considered.
because they themselves asked,
So whether that
we
has been,
projected our problem,
so whether they have considered it.
considered. That's what they were supposed to produce.
So I placed that document
Yes.
of January. All these things were discussed.
Okay.
Number one.
Ah.
And pre-bid meeting, Lordship would kindly see the pre-bid meeting date is of 11th of page 264. 264.
Pre-bid meeting, page 264.
264, the date is there. Tender important dates.
264.
Of the writ petition.
What is,
Why do I say?
no,
That pre-bid meeting of minus.
this is the tender.
Yes, tendered. I want to see the date, pre-bid meeting date and time.
Ah.
That 11th August.
Ah.
So in that meeting, they have not raised any issue.
Where is this?
Important 3, serial number 3, important tender report.
Yes.
On 11, they did not raise any issue regarding all these grievances. It is not our duty to invite grievances. We have to explain how the tender is to be submitted, but they have to give us an application that these are our grievances. We need changes of these tender conditions. And what I saw, Lordship, that was of January 2023.
This is in the NIT it is there. This
No, my lord,
NIT.
there is a pre-bid meeting that we are not disputing. What we were saying is, these issues are not discussed. Let the minutes of the pre-bid meeting be placed.
If they want to further delay the case, Lordship, that is the Lordship will definitely, if we have to produce those minutes also, we'll do that. But let the interim order go. The general public and the system should be in place. From July 2023, we are not having a proper process system in place. All on extension they are running and they are the beneficiary. Undue advantage they are getting.
Your page 50 dated 17/1/23. So we can, there is one way of doing this.
Yes.
We can say that let the BPCL examine this reply
Yes.
and
Ask
as soon as until they take a decision, this interim order will continue.
Continue.
Once they take a decision,
Lordship,
what will
Yes,
happen?
yes.
I fully, Lordship, let me complete my submission.
No, just I will allow you.
Yeah.
Only one thing. Will it be okay? Will it be okay, Mr. Saikia, if
So they submitted an application on 31st August, place 426,
31st August?
2023. After submission of the tender, and we have rejected. The rejected email is annexed, they have annexed it.
Which page?
Oh, sorry, we have annexed it. Page 426.
426. 426.
Page 425, Lordship will kindly come to annexer 3, 425.
425.
Request for, it is there later.
Yes.
Request for remodification of the transportation rates against new tender Hope this letter finds you well. We, the members of so-and-so, would like to inform you that with heavy heart that we are totally not satisfied with the current BMR in the above mentioned new tender. The present rates are inclusive of toll tax, loading and unloading both at NRL and distributor side. These things are already informed to you through various letters as there is high inflation in items such as lubricant, vehicle price, RTO papers in regard to lorries. Moreover, our truck drivers are demanding to raise their salaries. If we are going to participate, we'll be failing from all sides. Therefore, you are requested kindly reconsider. Next page is our reply. This letter is of Lordship 14th August.
Okay, so that has been now.
There's
that is gone.
a rejection of their prayer. So further consider it will be a futile exercise, Lordship. So
Okay.
if I am allowed to continue, Lordship, the factors which you consider.
So I think basically they have rejected.
No, my lord, this rejection, we got to know only when they filed the affidavit. But when we filed the writ petition, my lord, that they have not adverted to, you came up with that grievance.
Anyway, now they have, now it's here. Yes,
So it is to their knowledge, till now they have not challenged that also. Now page 100 and I am continuing, Lordship. Page 148.
148.
A continuation of the factors considering for coming to the assessment of BMR. Higher rates are given for trips beyond state borders due to interstate permit cost and other statutory and non-statutory charges relating to interstate transport. In case of, I'm sorry. So in case now, page 148.
Yes,
Have Lordship got it?
yes, yes.
So higher rates for interstate transportation, that is also considered. In case if transportation of 2 kgs, 5 kgs, 19.19 kgs, 35 kgs, 47, etc. capacity cylinders are required to be transferred, then the rate applicable shall be so and so, so and so, so and
These
so.
are, these are expert decisions. Who are we to decide?
Exactly, Lordship. And next
Yeah.
line, Lordship. There will be an escalation of 4% in rates on the beginning of the 4th year as well as 5th year on the non-fuel components of the rate
No,
prevailing
I
at
think,
the.
I think we can leave all this.
Yes, now.
I think, my lord, in view of this, perhaps, my lord, we have no case. Let us be very frank with that.
I'm not completing, Lordship.
No, no, I'm not conceding.
He's
He's
conceding.
considering that fine, Lordship. Because they are considering in their
No, no, my
affidavit.
lord, this letter was never brought to our notice.
Ah.
Only on the affidavit we got to.
Uh,
Of course, this is after filing of the writ petition. It was on 31st of August and we filed our writ petition prior.
Anyway, so because
If
now.
conceding, then I have no.
Not, will not record it. no,
I will not record. Huh. Okay, right. Heard Mr. K. Chaudhary, learned counsel for the.
Lordship, I would just like to give few judgments for Lordship. So that one specifically of Karnataka High Court.
Okay, okay.
On the same, that 3 paragraphs, let me read it, Lordship. It will clarify everything, the whole situation. The Supreme Court judgments, Lordship knows all this. Only the Karnataka High Court one judgment I will also give.
My lord,
Okay,
number one, some matter is there.
Okay, no
My
problem.
learned friend would be there.
Okay, okay, no problem.
My lord, we are, I
Proceed.
have made my position.
Yes,
clear.
yes.
After this.
ठीक है, ठीक है.
So for Lordship's satisfaction, Lordship, I'm giving.
Just to make the order slightly more beautiful.
Yes, Lordship. Maybe because everything has been considered here. So this is a judgment of the
I've got
Honorable
it, I've got it.
Karnataka High Court, the
Sir.
single judge, but it was upheld in the division bench also. Paragraph 15, 16, 17.
Saikrupa roadways.
Yes, Lordship. Same,
Saikrupa
they are also
roadways.
challenge of the BMR.
Saikrupa roadways.
Yes, Saikrupa, yes. Paragraph 15. Whether paragraph, it starts from the core question.
Yeah, the core question.
Yes. So 15, 16, 17. I'll not read out Lordship. Huh? And 19. Paragraph 15, 16, 17, and 19. And the Supreme Court judgment, 2 judgment. Michigan Rubber, Lordship, 2012, 8 SCC. 2012, 8 SCC, page 216. Michigan Rubber versus State of Karnataka.
Michigan, yes, para.
Paragraph 23, 24, 25.
23, 24, 25. Then
23 directly on fixation of the value of the tender.
value of the tender?
Yes. 23, because here also the BMR is the value of the tender. 23 B.
It says that, B. Okay.
Fixation of the value of the tender is entirely within the value purview of the executive.
Yes.
So this will
No,
be
no, you see, value of the tender is, there's nothing here because they have got to give the rate.
they have to give the rate.
That's all.
Now, when we estimate the value on the basis of that, they have to
However,
give.
yes.
So here also BMR is the value on the basis of which they can give their quotes. 5% more or in PWD, we always have the handle of 10%.
That rate band. has to be
Yes,
there.
band is.
Any other judgment?
These two will be sufficient, Lordship, because the Karnataka, this BMR whole excess, what are the factors to be considered? Everything is discussed here.
Okay, right. Right, Mr. Ken Chaudhary, learned. And you should have brought out this document in the beginning.
Which
And we
one?
could have saved this page, page, page 425 and 426.
No, we have, because their whole cases, again, they have to file.
No, if you had stated this 425 and 426 in the very beginning, then we wouldn't have to waste 1 hour.
I'm sorry for that.
No, no, it's just,
But very interesting, their reply, they says we have to pay money to the extremists also. That factor is also not considered in their reply. So
what-
they will be in trouble if I give it to the DGP lords.
correct, correct. Okay, right. Heard Mr. K. Chaudhary, learned senior counsel for the petitioner.
There are two petitioners.
Huh? There's only one out there. Okay, two petitioners, petitioners. And Mr. D. Saike, learned advocate general,
Senior advocate here.
senior advocate, senior advocate, appearing for,
The Bharat Petroleum, BPCL. 2 and 3.
appearing for the respondents number
2 to
12, 2 to 5.
2 to 5. Central government is 1 item.
Yes, 2 to 5, assisted by Mr.
Both of them.
S. Bothakur.
Yes, yes.
Mr. S. S. Boy appears for respondent number 1. CGC appears for respondent number 1. Huh? The petitioner number 1 is a registered society. You just take this order dated 16/8/23. Just take this para 2. Para 2, para 2.1. The petitioner's counsel submits, the senior counsel for the petitioner submits that in view of the benchmark rates provided in the NIT dated 4/8/23, comma, the petitioners would not be able to earn any livelihood as the rates that are as the rates for carrying LPG cylinders would be the same as had been fixed in terms of the earlier NIT dated and the NIT dated that 17, what was that 17? Earlier NIT. That's it, earlier NIT. What was that 17 NIT? What was the date?
152, I think.
Among annex one of them, sir. I'll give lordship. We have annexed them. No, no. No, the date will be the 90 date will-
Anyway, huh?
152 affidavit filed by them.
INIT dated,
The number is there, date,
dated, okay, this is,
number.
uh,
BPCL LPG PKD ER 2017/03. Pre-bid meeting 14/12. 7, I think it is 7/12. The date of downloading period starts.
okay,
Seven.
dated, okay, dated 7/12/2017.
Lords.
Next. The petitioner also submits that next para, the petitioner's counsel submits that it should be that the respondents number 2 to 4 via email dated 19/9/22 had requested the president of the petitioner society to provide the details regarding the expenditure that the transporters would have to pay at the present date to carry out the transportation business of carrying LPG cylinders. The petitioners, the petitioners, the president, what is this? It is the
Page 50.
page 50, the no, that's right. In reply to the said email, the petitioner society submitted their suggestions via letter number NE 01/2023 dated 17/1/2023 to the respondent number 4. Pusa. The petitioner's counsel submits that no decision has been taken by the respondents number 2 to 4 to the petitioner's letter dated 17/1/2023 till today, and as such, the present date petition can be disposed of if a direction is issued to the respondents number 2 to 4 to take a decision on the petitioner's letter dated 17/1/2023. Bracket annexure E, huh? Yes, right. Pusta. Next. The learned senior counsel appearing for the respondent number 4, 2 to 4, submits that 4 to 5 submits. The petitioners submits that the respondents number 2 to 4 had issued an NIT dated 4/8/2023 for road transportation of packed LPG cylinders for BPCL Numaligarh Refinery Marketing Terminal, Assam. Pusta. The petitioners on getting to know of the issuance of the NIT submitted letter number 14/2023 dated 14/8/2023 to the respondent number 4 requesting remodification of the transport rates against the NIT dated 4/8/2023. We say NIT, the 4/8/2023, comma, that is e-tender ID dash 13036. The this person. The respondents number, the respondents thereafter made a reply to the petitioner's request for remodification of the transport rates against the new tender, against the new NIT dated 4/8/2023. Letter dated 14/8/23 by rejecting their request and asking them to participate in the tender process. Full stop. Next para. At this stage, have I said the letter dated? Why letter dated? No, 14/8 is the other one. Now this letter dated is 31/8/2023. Next para. At this stage, next para. At this stage, Mr. Ken Chaudhary, the learned senior counsel for the petitioner, submits that he does not wish to press this case any further and concedes the case in favor of the respondents in view of the fact that the question of in view of the fact that the respondents have rejected the petitioner's request for remodification of the transportation rates against the new tender dated 4/8/2023. Correct? It is.
Yes, ma'am.
Comma, as can be seen. No, tender notice date 4/8/2023, comma, that is e-tender ID dash 13036. But that is listed everywhere. That number is there.
Yes.
Next para. Mr. D. Saike, the learned senior counsel, submits. This you put it where Mr. D. Saike is, submits that the Karnataka High Court in the case of so and so, reported in Manupatra MANU has held that has held that the logical system employed by each oil company in finalizing the transportation rates for petroleum products is a testament to their commitment to economic prudence, regulatory adherence, and strategic acumen. Full stop. As such, the judicial intervention is warranted only when the procedure adopted by the public sector companies is found to be tainted by arbitrariness or malafidings. Full stop. He submits that by taking into account the ratio decided by the Karnataka High Court, the benchmark rates indicated in the tender notice dated 4/8/2023 cannot be the subject matter of judicial review in this writ petition. Full stop. He also submits that in terms of the judgment of the Supreme Court in Michigan Rubber India Limited versus State of Karnataka and others, 2012, 8 SCC 2 and 6, fixation of a value of the tender is entirely within the purview of the executive, and the courts hardly have any role to play in this process, except for striking down such action of the executive if it is proved to be.
Sorry to interrupt, my lord. Lordship has recorded, I have considered, my lord.
Yes.
Instead of lordship,
Oh, not considered, that's it. Okay, yes, that's it, considered.
instead of that, my lord, we'll challenge this order. That's all. We will challenge on matter different on that.
Okay, okay, I'll correct it.
Yes.
I'll correct it. In this process, except for striking down such action of the executive, if it is proved to be arbitrary or unreasonable. Full stop. Full stop. That's all I think. Next, next para. In view of the fact that the main ground for challenge made by the petitioners counsel with regard to the
Non-disposal of the representation.
non-disposal of the petitioner's representation dated 17/1/23
Yes.
having been taken care of by the letter dated by the 240 by the letter dated 4/6
31st August 23.
by the letter
Page
dated
426.
by the letter dated 31/8/23 issued by the
Authority, my lord.
issued by the respondent number 2 to 4 by the respondent BPCL there is nothing left to adjudicate in this matter. Accordingly, the writ petition is dismissed. The interim order passed earlier stands vacated.
Highly obliged, Lord.
I put that on.
My lord will kindly take care of that part.
I'll take care of that. Concede party first. There we put it. Put note you put. I put that inside. What else? Item 3.
Matter pertains to non-payment of contractor's bill, Lordship. First up, it was called for the council.
Yes, what is what is the matter? You have not been paid your. Yes.
Our names are probably not reflected in the court list.
Okay, Mr. U.
Sharma.
Appearing on behalf of the PNRD,
Yes, sir. Lordship.
submits that he was unaware of the listing of the case And as such, and as such, he is not prepared to stop. List this matter after a week.
Lordship, can we get 2 weeks?
This is a
Because
matter after
we
2
don't have
weeks.
the brief.
In the meantime, Mr. U. Sharma shall obtain instructions as to why the petitioner has not been paid his contractual bills. Registry to reflect the name of Mr. U. Sharma.
Lordship, the standing council's name.
May reflect standing council SC,
Yes,
SC PNRD in the cause list.
I mean, item 7.
This item may be passed out for the today.
Okay, right. On the prayer for adjournment made on behalf of the petitioner's counsel, list the matter after a week. That's all? Oh, there.
Item 9.
Wait. What is the matter about?
Challenge and award of the labor court, madam.
You are for whom?
I am for the garden management. Issue pertains to the matter that Plantation Labor Act.
Huh?
Plantation Labor Act. There is an Assam, in Assam, my lord, there is a act called the Plantation Labor Act of 1951. Under that act, my lord, depending on the size of the tea garden, we are required to maintain certain medical facilities. Depending on the size. Now what has happened, I'm just giving a synopsis, a brief synopsis. The worker, my lord, his wife was diagnosed with cancer. Then she was referred to the Jorhat Civil Hospital. Thereafter, they took him to a private hospital in Mumbai. Now, after coming back, the entire bill has been served upon us, and the Labour Court has directed us to payment. Now, under the Act, we are not, I'll satisfy your lordship that I am not required to do so much. That is the case. Should I start on?
Why you're not, because he did not,
No, my lord, under
You have
the
not
Act, my lord, I am required to maintain only an OPD, depending on the size of my garden. There are 2 types of hospital. One is a garden hospital and one is a group hospital.
group.
Group, my lord, that is the definition here.
What is a group hospital?
It's a big hospital, my lord, some gardens, it has, you have to maintain certain facilities, extra facilities. And nowhere it says that, my lord, a hospital, a tea garden will have an oncology treatment center also, my lord. And that is the finding of the Labour Court.
No.
That facility was not given in the hospital. Although, my lord, under the Act, I am not
No,
required.
but then why shouldn't you pay for the workman?
No, it has to be a condition of service, man.
Correct.
It is not there. If I am required to pay for each and every workman and their family, my lord, I'll have to close down my business, my lord. We are a small tea garden, my lord, having 160 workmen. I'll concede to that extent that whatever facility I am required to maintain in my garden, if I have failed to give that, then the Act itself provides that how that is to be remedied. Now, for big treatments, if the workman takes them to a private hospital, if I have to reimburse, my lord, I'll have to shut down my business. There is a concession on my part from the manager's side that till the treatment in the Guwahati Medical College, I am ready to reimburse. Although I respectfully submit, my lord, under the Act, I am not required to pay that even. But there is a concession, I have to admit to that part. So far as the treatment in the either in the Jorhat Civil Hospital or the GMC, my lord, I may be on that concession, maybe not taking it as a precedent. But taking treatment in higher private hospitals, if I am required to reimburse, that will be very difficult. Because the facts are not in dispute. Another ground I am taking also that he is not covered under that Act because of the wages. I'll demonstrate everything.
Yes. So his basic case is that under the Act, he is not liable to pay any of the medical bills that has been incurred in the other hospitals, big hospitals. What have you got to say to that?
My lord, it's a condition of service, my lord.
It's a condition of service.
Yes, my lord. The workmen as well as their family is entitled to free medical facilities.
Okay.
On that, I will satisfy. Maybe may I pray, my lord, it may be fixed a date, my lord.
Oh, not today.
Not today.
I will
Yes.
have to take your lordship to labor, plantation labor act.
I'm ready, my lord. I'm prepared. I can start.
He is not ready.
As your lordship.
There's no point hearing one
Yes,
side
no,
on.
no point in hearing in a piecemeal basis.
Right, on the prayer for adjournment made by Miss
Eh, matter, sir, yeah.
the counsel for the respondent, list the matter. After list the matter when?
Any date, my lord.
April. Eight. Eight,
Eighth is a Monday, my lord.
seven, eight, nine.
Ninth. Ninth.
Well, in this contempt petition, although it's of 2016, this morning I was told by my colleague on the other side that both the alleged contenders have died. Just that said, that's okay. But I believe that since initially the petitioner was a grinding mill, so therefore someone in law would be operating it. Necessarily, I need to serve notice. I trust my colleague. That's a different issue. I need to serve notice. Then get implemented. There's no concept of substitution in a contempt case. I have to get the one implemented.
Correct.
If need be.
Correct.
In all fairness, my lord, may I pray the matter may be listed sometime in May or June? Because in the meantime, I have to serve notice actually. Then comes a denial by them. Notice that.
So why do you want it listed in June?
Because now I'll write a letter to the new one stating that the concerned lawyer has said upon which a submission was made, accordingly kindly comply, because our standards have not been complied. Anyways, once we write, he receives, and then
Why do you want such a long date?
look, it will take 2 months in between.
Now is March, April, May,
Because
June,
we
4
have-
months.
April, we have got the BU holiday. Some meet is there. Sometime in May, it might come in, or after BU. Because in between, we must give him some time to comply also.
This contempt petition is of 2016, they're never going to comply.
I understand, but I wanted,
And you're not in a hurry,
we want the things to be done.
but you're not in a hurry.
We are, but since the person. has-
Probably your grandson will later on take up this case also.
This morning I was told someone died, they didn't appear, it's okay.
Huh?
But since they told me that both the persons are dead, I take it to be knowledge from this morning.
If they're dead, you just ask the persons who are the others, who are they? Who are the respondents?
Respondents,
Government.
no. It's a Ratni Devi Jalan and Milord Swarnamal Jalan. They have died. But since
Who are they? Who are they?
they are Milord the operating the mill.
They're the corporation.
They're the owners of a mill. So they have died, but the mill must be operated by someone. I need to serve notice sometime in April, Milord. I need to serve.
Okay, correct. On the prayer for adjournment made by Ms. S. Bani, who submits that he has been informed that the respondents have expired. List this matter after 2 months.
May I pray one thing, Milord? Informed by the council for the other side.
I've been informed by the council for the other side that the respondents have expired. Come on, list the matter after 2 months.
Okay.
This is going to be a long drawn out affair.
No, it is our first item to. Second item will be the first. Oh, no. Second item.
Second item will be the first item.
8150.
815017. And the next is connected, but
This will take care of everything.
may not take care of everything, but it will have some impact on.
Okay.
second case. So it will take a little time, and there is no doubt about it.
Will you complete it? How much time will you take? Today it will be difficult. Okay, then we'll adjourn. There's no point hearing it halfway. What do you say? What do you, I don't know, will you be able to complete?
Let it start, not myself. Let it start.
Ah,
Think about tomorrow.
we are packed. There's no question of spilling over. We are packed. We are,
It's a hearing matter anyway.
yeah, it will at least not in 1 hour. I don't think we can finish in 1 hour. We can finish one case in 1 hour? No, because I don't think so. Because the first case, what is the issue about basically? Basically, Milord, basically, Oil India, Milord, has two sets. Your Oil India? I am appearing for Oil India. I have come in place of my esteemed junior, who unfortunately passed away, Suren Sharma. So I am deputy for him. Now, Milord, Oil India has a set of rules for recruitment, even for categories of this workmen. It has also, because of its extent of operations, need for contract labor, for which Milord this 70 Act has been enacted. So that is the contractor supplies the labor, that is contract labor, and they are there. So these two sets parallelly go together. So there is a labor contractor who supplies the contract employee. Not one, Milord, there is a huge number of contract laborers, contractors, because they have all, Milord, they are engaged in exploration of oil. So it's a continuous process in different areas where they. So that is one aspect. Yes. That is one aspect. Yes. The employment of the contractors as one aspect. One aspect, and that is the aspect we are concerned with. Okay, okay. And so they are recruited, and Milord, over a period of time, the conciliation settlements take place in respect of their demand, and Milord, long-term conciliation agreement. But they are the employees of the contractor. Contractor. Then if, why should there be conciliation with you? No, Milord, the conciliation with the contractor, you mean? Yes, yes. No. Milord, the demand is really raised against us, because principal employer is the company. Correct. The contractor is the registered contractor having a license under the Contract Regulation and Abolition Act. And the workers supplies the labor, and that is why it's called contract labor. And they raise disputes not only before the contractor, but basically before you. In reality, it has to be before the principal employer, because it is ultimately the contractor pays them, but the amount has to go from us to the, I mean, that is the way. But it has to go from you to the contractor, correct? Yes, and then to yes. So even the dispute or whatever the problems, it has to come through the contractor. That is what one of the arguments and one of the issues is that we told Milord, the officer concerned, Deputy Labor Commissioner. This is one thing we raised in our response, that you must also have the contractor, because he is the person under the Act who maintains the registers and all other operations, and he supplies and he controls. We don't have disciplinary control over that. Therefore, that was one of the pleas, Milord, we have taken. Unfortunately, as your lordships will see the order, which is a longish order, that aspect has been virtually overlooked. So basically, Milord, we are concerned with two settlements which took place in conciliation. One is, Milord, in 2010 for 10 years. It's a long-term conciliations. And another is 2013. So it is divided into
work, WCL, work charge labor, one, that is the 2010 settlement. Then work charge labor 2 and 3, listed 2 and 3, that is the 2013. For 10 years or so. This is actually, for convenience, it is called listed 1, listed 2, listed 3. Listed 1 is the first category who were possibly recruited earlier. 2 and 3, listed 2 and 3, the cutoff date is 2000. Pre-2000 is listed 2, post-2000 is listed 3. That's, I mean, for convenience. So these two agreements and settlements were in conciliation. So that has an impact under the industrial dispute side, as your lordship know. Because
No. Please enlighten me.
yes, I'll elaborate that.
Yes.
The Industrial Disputes Act, my lord, puts the conciliation settlements almost, because of the decisions of the court, at par with an award. It's a long, my lord, because it is assumed that when you do the conciliation and the officer of the rank of that Deputy Labor Commissioner or Assistant Labor Commissioner who conciliates, my lord, then, my lord, it is thought that they will take into account the requirement of the laborers, and the settlement should have lead to peaceful situations, and there should be collective bargaining and then stability for a period without raising further demands on account of financial matters. That's the idea, and that's how Milord Supreme Court has interpreted Section 18 of the Industrial Disputes Act, which I will play. So these two settlements were in place. One 2010, the other 2013, almost similar. That, my lord, confers several rights to the contract laborers. One is with regard to the wages. The other, the facilities and the allowances they will get. And there is a clause that during the currency of this settlement, no demand will be raised involving financial implications. And if such a thing happens, it may lead to withdrawal of the benefits which are being given. So this is how, my lord, these settlements are structured. So if your lordships see, the settlement itself indicates the basic pay, the dearness allowance formula, and all that which is taken care of. Then it enumerates about 6-7 allowances, and the total sum which a employee covered by these settlements are concerned will be a reasonable sum if you compare with other PSUs in the same field or in the region where they are operating, mainly Assam. The salary position and the allowance position, total pay packet of the workers are a fairly reasonable thing and far above the minimum prescribed by the central government for industrial workers. So that is the situation. The details I'll indicate to your lordship.
Okay, just one thing.
Yes.
When the settlement was made,
Yeah.
a contractor was not a part of it.
Unfortunately, we said before the conciliation officer, in fact, before the this Deputy Labor Commissioner, who is the authority under the 70 Act to determine these wage structure. that contractor should be made a party because he is the key player in the whole scenario.
He's the link between you and the
Yes.
labor.
Link, as well as he is the person who is required to maintain very many registers under the act and the rules. So have him here. That is what we also pleaded in our writings. Unfortunately, the officer concerned didn't think it wise to have him.
And you did not challenge that order also.
Because, it's a very peculiar sort of procedure which has been adopted. And that is one of my grievances, as your lordship will see. Because this is a power, which is conferred under Rule 25 of the rules made under the Contract Labor Regulation and Abolition Act 1970. What Rule 25(5)(a) and B says is that if the contract labor does a work which is same and similar or similar to a work by the regular employee of the company, then the wages will be same as that of the permanent worker or regular worker. Otherwise, it is as per the minimum wage notification issued by the settlement under the Act.
So,
So the demand after the settlements took place, it was peacefully going on. There was no problem. They were getting their.
but what was the settlement? What was the settlement? That they will get the same pay as the regular employees?
Not same pay because they don't do the same work. That's it.
No, but what did the settlement record?
Yes, it's an annexure A
Huh,
and B.
huh.
2010 is annexure A at page 31 and 2013 is annexure B.
So what does it say? That they will get the same pay as?
No, it has enumerated the payments, the wages to be paid to them,
And
formula of dearness allowance, and all other benefits which are going to be given.
and you are paying this directly to their accounts.
Yes, not to the accounts. That is the salary structure, which is settled by the
Settlement.
settlement. And we pay the same amount to the contractor through whom the workers get it.
Okay.
Yes, because.
So what about the EPF, all the provident fund and all? But that the contractor pays it, or you pay directly?
No, we don't pay. I think it is all statutory dues are paid
By whom?
by the contractor or deducted from whatever they have to pay, because that is provident fund and others, you have to deduct.
You have to deduct, but if he's your employee,
Yeah.
then he'll have to be deducted from you. If he's not an employee,
Yes, I quite see what your lordship is saying, but this is a situation which is created under the act itself, namely that the obligation of payment is fastened to the contractor. In case he fails, the principal employer has to pay.
maybe,
And he may deduct from the.
maybe, but maybe that is the way it has to be done.
Yeah.
But the issue is whether you paid all the payments through the contractor or you all did it through your offices.
Through the contractor.
Everything,
Everything.
EPF also.
Yes. Because for all practical purposes, he is the employer.
They are shaking their heads. They are saying no.
No, oil pays the money, but ultimately.
Did it go through the contractor's
Yes,
account?
it
That's
goes
what I
to the
wanted to know.
contractor, because contractor is the immediate employer and.
No, because you see, right now, what I want to know is only the facts.
Yes.
Now, in that, this fact is being disputed by them. The fact that that you paid through the contractors, the dues of the workman is being disputed by them, dues of the laborers.
That has no consequence.
No,
over
no
the issues
consequence.
are concerned,
Okay.
Milord. That is, it's a matter of detail, but substantially it is this. The money goes from the company through the, to the worker, through the contractor, because he is the immediate employer. That's how it is mentioned in the act itself. And if you.
No. Mentioning in the act and the actual work,
No, no,
and
that is
actual
the-
manner in which it has been done may be
No,
different.
the whatever is prescribed, the company is following that. Namely, that if he fails to pay, then the principal employer becomes liable under the act. The worker's interest is protected. He cannot be deprived of his dues. Whether he pays through the contractor or
No, but that can,
otherwise
but that,
doesn't
but
matter
that
much.
can have a bearing.
Huh.
If you take up the role of an employer, not the role of an employer of the contractor, but the role of the employer of the laborer.
Ultimately, Milord, that is so. That is how the scheme is. Who is he working for? Obviously for the work of the company. And whose ultimate liability is to pay in case the contractor fails. That is also provided in the act. It is the principal employer. So reality is that, but the contractor comes in between. So certain consequences follow from that. But that is not decisive about the issue which is arising for your lordship's
Okay,
consideration under this act. Whether it comes higher or it comes straight, it doesn't really.
Okay.
No. Because the settlement fixes the scale and the allowances. And the statutory dues, of course, by the statute. Question now is, it was followed peacefully. There was no dispute for several years after the settlement was signed. Then, Milord, a new union springs because there are several unions. The settlement was also possibly signed by 3 or 4 unions. So a new, completely new union now comes into the picture and tries to take away some of these employees from the membership of the other unions. There the problem has started. The new union has done 2 things. First, it has filed a writ before this court praying for regularization of their service when an advertisement for recruitment was issued. Unfortunately, they didn't get a stay order.
Fortunately, you mean.
Fortunately or unfortunately.
For you, it'll be fortunate.
Fortunately, yes.
Depends on which side of the fence you're
Yes,
on.
yes, your logic is absolutely right. Now, my lord, ultimately, it became infraction. But the story doesn't end there because in this proceeding, the new union tried to say that no, they never moved the High Court. It was some other union, which is again a misleading statement, knowing to be incorrect by the union. Because it's a matter of record, brother. It has been disposed of as infraction. We have given in number of the case and all that. So it is, this is not very of great consequence, but this is what they first did. So they didn't succeed there. Then they moved the Deputy Labor Commissioner, the Deputy Chief Labor Commissioner, which is the prescribed authority under the Act, under the Contract Labor Regulation and Abolition Act 1970, for as the statutory authority for determining whether they are doing the same and similar work, and in case they are, they will be entitled to the regular salaries given to the regular employees. Or alternatively, if that is not the position, the act provide, the rules provide that it will be as per the minimum wage notification issued by the government of India. So that initially, even when they first moved the Deputy Chief Labor Commissioner in 2015, the application was designed under the Industrial Disputes Act, asking for regularization on that count that they are doing the same work, which the Deputy Labor Commissioner converted into an application under Rule 25 of the rules under the 1970 Act, which provides the power to the officer concerned to determine in the case of a plea or a claim for same and similar wages. That is how, Milord, the demand sort of was channelized after the application filed by them, initially for the purpose of Industrial Disputes Act, but now the officer concerned has converted it into an application under the rules under the 70 Act. And that is how the process started. Then he asked for our company's views, which was given, where two things were said, basically. One was that these are covered by settlements, conciliation settlements, which under the Industrial Disputes Act have a position to the judgments of the court. And there is a clause that you don't disturb the situation for a certain period, and there was an agreement with regard to that. Therefore, they said that this will completely violate the scheme, which is disclosed under the Industrial Disputes Act for purpose of conciliation settlements, which are virtually taken as at a pedestal of an award. So the trouble started there. Then we filed our reply, and then he took a very peculiar sort of procedure.
No, what was the prayer? What was their prayer? To regularize them?
Initially to regularize them, and then they, after the letter came from the officer concerned, they made it an application for similar wages as paid to the regular. They came under that Rule 25 scenario. And thereafter, the officer concerned initially deputed his junior to look out in the matter. He had some possibly problems, we don't know what, but we have found it during the course of the proceedings that officer did not do. And ultimately, the Deputy Chief Labor Commissioner notified us that he is coming for a spot verification on between 3rd and 5th May 2007. And he landed up at Julieta. Now, he visited 8 departments out of 36 departments, picked up 14 contract labor and 13 regular employees, and took their statements. The statements were never supplied, but officers were present when the statements were recorded by him, and that ended the inquiry. As your lordships will find when we place the cases, the initial burden is of the applicant to show that they are doing the same or similar work as a regular employee. That's the condition precedent to get that similar wage. Otherwise, you don't get it. Then the settlement is better than the minimum wages notification. Therefore, this is the peculiar procedure he was following. And then he says, okay, now you give a final submission. And the company writes to him, reiterating everything and saying that they don't do that similar or same work, and it is a qualitatively different thing, and therefore they are not entitled. And the two objections which were raised initially was repeated, namely, you should have the contractor before you in this proceeding. Secondly, there is a settlement in operation. The benefits are taken by the concerned workers also under that settlement. And therefore, in view of the law, you can't allow them to violate that settlement, take the benefit, and again make fresh demands, which is not contemplated under the settlement.
But the settlement was for how long?
For 10 years. Every time.
And that settlement was made when?
One was in 2010, the other was 2013. Earlier to that also.
Now it's 2014. Acha, but
Yes, now again, 2022, the new settlement has come into operation for another 10 years. And this distinction of 1, 2, 3 listed has gone. It is only one group. And they are all combined. And this is in 22, the last, which is running now. That is, was executed between the parties. So that is the present position. Therefore, the peculiar procedure which was adopted is that, as I have said, that he comes, he makes an inspection of 8 departments, picks up 13 and 14, and then he passes an order. And the crucial part of the order is, it's a longish order, but he comes to a categorical finding that the works done are not, by the contract labor, are not identical with the works done by the regular employee.
Not identical.
At page 75, your lordship will get that finding. Forget for the time being that he didn't follow a procedure which was known to law, because you are the authority under the rules to determine the question as to whether they are doing the same and similar work.
How is it supposed to be determined?
Because your lordships have laid down how it has to be done. Through judgments, basically. Through judgments. Supreme Court has said, your lordships have said, the whole idea is, my lord, this is a matter which is normally a matter of adjudication by an authority under the Industrial Disputes Act, namely a labor court or an industrial tribunal. Now, this act confers this power by Rule 25 on an administrative officer. But that doesn't take away the requirement as to how he will exercise the power and how he will
come to a finding.
And how he will come to a finding that either they are working the same way, same job, or not. So that is a matter which has to be on basic principles of adjudication, because it is something which is given to a statutory authority, and he has to at least do a few things.
So you're not telling us how it has to be done.
Because your lordships have, I'll place these cases. The lordships have said it is the burden, first thing is the burden is of the person who is claiming it. Secondly, the authority concerned has to apply his mind to the materials produced.
Okay. Okay,
to- To show the similarity done between the two groups. And then you deal with that evidence which is coming, and then you decide. That's the minimum, whether it's an administrative inquiry or a quasi-judicial inquiry, that is the minimum. And that is, I'll say so from the cases, that is the yardstick which was applied. So far as this part of the case is concerned. So the problem was they have the formalities are absent. I am not insisting on formalities. On substance, you must first make an application that this is our work, this is the same work as done by the others, and therefore we are entitled to the same. That's the minimum. That is basic. Two, you have to put some evidence before the authority concerned to enable him to.
yes, okay, I get it. Yes, I'm clear. Then, next point.
Yes. So this is how he has gone. Even assuming that whatever violation has taken place with regard to the requirements of a fair procedure, what has he ultimately decided? His basic finding is
not
that it is not identical. And the Supreme Court has
Was a
said-
typographical error by mistake, it has been inserted.
No, it is not. I'll place that page below. There is no scope for coming to that view.
Okay.
It is very categorically stated.
Okay.
And he said that nonetheless that they have worked for long, acquired some experience, which is true. But that doesn't entitle them to get the same wages. If he says that the work done by them is not identical with the permanent and regular workers of the company, then the condition precedent for awarding the same wages vanishes. Because it is the view of the courts that in order to get that same wages, you must also come to a conclusion on the materials available.
Correct, that it is identical.
That you have to be doing the same or similar work. If you come to a finding that it is not identical, there is an end to it. Whatever else will not substantially, that is that would not entitle the statutory authority to come to a conclusion that you pay the same wages.
How much more time will it take?
That, your lordship can have it on Thursday, we'll finish it.
No, we don't, I don't think we are. Huh? You see, all.
The authorities of the opinion that the contact was not there, they are all territory.
No, you are talking about your case. I am not on that at all. No, that is absolutely, he is doing the second case, Milord. We are not, I have not finished the first case.
He's on the first case.
No.
He's not on your case.
No, you are.
Yeah, no.
First means
The second case is the first case right now.
2017 case.
We are going backwards out here.
But our only anxiety is that the date of the award, the benefit that comes to you, only recently I think some benefit is given.
No, that is also wrong. Absolutely wrong.
It has to be hard.
No, had to be, but the issue is not that. The issue is that, you see, we have been fixing dates for hearing all the time, every day.
Yes.
Only thing is that, if you are not, if you can finish, we have got no problem, but you didn't have time to finish, that's why. That's why we wanted to know the basic gist, so that next time we hear it, won't take that long.
Yes.
Uh,
I will take just half an hour.
Oh, just how.
We lawyers are very bad profession.
Yes, yes,
Don't go by us.
yes,
We are
yes,
very bad prophets
yes, yes.
about the time we will take. And therefore I never make that.
That promise.
Because you
So,
never know how the-
I don't know, some other day, not this week, not
Then,
possible.
I have a little personal problem. I have told them, they know it. I am required to go out
Okay, okay.
for my two operations really.
Oh,
So I have a problem. And then when they were thinking of a cataract, they had to do an ECG.
oh,
And that has again revealed a little problem.
okay, okay.
So I may have to get another operation first
Oh,
and then go for the eye cataract.
okay, okay.
So I have been advised,
When?
I am required to go as early as possible. Because it's
Then you go, health is the way most.
yes, that I think my learned friends will not object to that. I have spoken to them also. Have it after Bihu April. Because I think I'll take about a month for all these operations and rest.
Okay, okay.
So have it sometime in after the Bihu vacation in April, because that will be better. Yes. You can.
Okay, you fix a date.
Yes. April, no? You can have on 23rd or 25th. Or 25th.
I leave it all to you all, decide.
23rd. 23rd. 25th. Oh, it is first to all of Ali designer problem. 25th will be better. 25th April, Milo. I hope I am all right. Otherwise,
Okay, I don't know, any objection?
No.
The counsel for the parties. Submit that, no, pray that the matter may be listed on 25. Oh, praise allowed, this is the matter on 25.
25 April. For further hearing your lordship may.
I don't want baggage
Okay.
to follow me
Yes, your
everywhere.
lordship, please.
If I am here, I will.
It has been so,
I have.
it has been so
Ah.
that it has moved from court to court.
Milord, first case, first day.
It has moved from court to court.
Yes. Milord, what has happened was first time when it came, I argued. Then my learned friend argued, and my learned friend Mr. Pegu for the government has argued, and
The case was adjourned.
adjourned.
What to do, y'all, three stalwarts are there.
Ultimately, it came to another bench.
And then another second time, it came before another learned judge, and it was hard for about half an hour or so. It is slightly more or less than yours. And now this is the third. So
No,
I
but,
give it to you.
but I didn't go deep into the merits. I
No,
just,
no,
I just wanted to know the gist.
that is what I have given, tried to give it.
So once you know the gist, then it
Ah,
becomes easy.
No, that is the crux, because what
yeah.
your lordship has virtually pinpointed the issue. So it is that, basically.
They also know where you're going to attack.
I have given them the indication
Yeah.
twice over, so this is the third time, there is no problem with that.
You see, saying, keeping it part-heard is a problem. Sometimes it follows you to all other benches also.
Problem one.
But it was hard by two benches earlier.
No,
To some extent, as your lordship is.
the problem is, you all are wanting it on 25th April. pretty long.
Yes.
I'm quite sure by that date I'll forget what I heard. today.
No, no, correct, absolutely. Right.
If it was, say, the week after next week, or, it's still short, the memory I'll remember. But 25th April is too far. 25th April. We all agreed, correct, 25th April? Huh. This is a matter on 25th April. No partner. If I'm still in this bench, we'll dispose it off.
Two learned judges earlier have said that for further hearing, but possibly I am given to understand nowadays courts do not make it part-time. Therefore, I think.
No, sometimes we do. Only problem is sometimes our benches change also.
But that is why possibly the roster changes, the subject changes, all that. So that is an issue where there's.
When the roster changes, whether the automatically the case also changes.
Yeah, that is what happens, because
That is
I
what
don't
is
know,
happening
it was
with this
never
case.
there before when we started and for many, many years thereafter also. Because if I had argued this matter 20 years back for half an hour, the court would have made it part-time. Now I find that even if I have argued for the whole one half, I didn't get an order of part-time. But that is because possibly there is an understanding among the judges that it should be. No. Why I am saying this, it's not.
You see, the problem is, when you are having a certain bench, and you have a different bench matter coming to you,
Yes.
it causes slight
Possibly
confusion.
it
at
is
times.
because of that, it is
Otherwise, your issue is basically already clear.
clear.
Basically, it is with regard to that,
Absolutely.
whether that,
Whether you get the same
whether you get the same wages or
Right.
not, and whether the decision, the finding made on the basis of his
Own
inquiry done by him and in the manner in which it has been done would justify such a finding. That's all.
Correct. That's about all. That's about all.
There's nothing else beyond that. So it's basically a question of, I think, citations being produced by you.
Yes,
There's nothing else.
Nothing else.
Factual, that's the.
His own finding negatives application of the equal pay rule.
So that is what I mean. I gather from what.
And they have not been given equal pay.
No, because equal pay is dependent on.
And the caste divided. That is the crux.
No, sanitary is not here in this matter. Don't go to sanitary straight away. No, we are concerned here.
No, he's not on that.
No.
The petitioner's counsel is saying that to be given the benefit of the same pay, there should be a finding that he's doing equal kind of work. Yes, equal kind of work or similar kind of work, basically.
That finding is there.
And that finding, so he's now disputing the basis for coming to that finding.
No, my learned friend is talking about the second case.
Okay.
Where he is appearing. We are really doing the first case.
Yes.
Which is the second in the list.
Yes.
But that is 2017 is the first case. There, the categorical finding is what I have told you.
Yes, I understand.
That this is not identical.
So then why is it listed together? Why is it tagged? If the issues
Because
are,
it
if the
came
fact
together, overlapping is there. But
There's
you
overlapping.
can't say that it is the same thing. Because the orders are different. And in
findings are different.
Findings are different. In this particular case, that finding is absolutely clear.
Okay.
And
in the other, the finding is different.
My submission that on the basis of that finding, he
couldn't have passed the order.
The application of the principle of equality.
Now you have made me guilty. That's the problem. Anyway, but I can't help it. You see, the thing is that you all are not going to finish in time. And because he's got some problems. So he wants it on 25th April. So we'll list it there. Any other matter? No.
It will be taken as a first attempt.
I have no objection.
I don't know, let it come in the list. But what you can do is, if I'm still sitting, then you can mention,
Yes,
maybe at 2 or something you can.
yes,
But you mentioned that on that day, you
yes.
said this.
Your lordship will remember. God bless.